Hello, welcome to the second day of Tallinn Winter School of Cyber Diplomacy. We have a busy day today with two panels on international law and capacity building, as well as a cyber resilience case study for all of you who would like to build a more resilient cyber infrastructure in your nations. We will start with a keynote intervention by Ambassador Jürg Lauber, who is serving as a chair of the United Nations Open-Ended Working Group on cyber issues. Ambassador Lauber is also the permanent representative of Switzerland to the United Nations and was serving from 2015 to 2020 as the permanent representative of Switzerland to the United Nations in New York. Hello, Ambassador. How are you?
Hi, Heli. Very good to see you. Thank you very much for having me.
Please, the floor is yours.
Thank you very much. Excellency, dear Heli. It's great to see you, dear participants and colleagues. Again, thanks very much for having me. I'm talking to you from Geneva today. Of course, I would have loved to be there. Everybody else in Tallinn, as we all know, not possible these days. But I want to say, Heli, you and your team, once again, I'm impressed by how you use the modern technology. With due respect to everybody else, there's not many or not even another member country I know that does it so professionally, using these technologies and bringing us together, at least in a virtual. Colleagues, Heli asked me to say a few words about where we are with this open-ended working group on cybersecurity. If you agree, I would say a few words again on the history, how we came about. The open-ended working group, also the other one, the group of governmental experts, tell you a bit about where we are in the process and try to give you a bit of an outlook on the next and last phase that is approaching very soon. Now, the history, I assume most of you are very familiar with how we came about. Even before these two processes, this open-ended working group and the group of governmental experts started, the UN has been looking into the issue of ICTs and their impact on peace and security for quite a long time. The first General Assembly resolution on the issue was introduced in 1998. I like to say this because the UN is often accused of being behind and not taking up new issues fast enough. Here, I think we have an example where the UN reacted to developments out there very rapidly. Since 1998, since that first resolution, and up to 2018, we have seen 5 different groups of governmental experts, smaller, I think anywhere between 15 and 2 experts each, discussing the issues and building up an international framework for responsible behavior in cyberspace. This framework exists or includes 4 elements essentially. One is a list of norms of responsible state behavior in cyberspace. The second one is the formulation of a common understanding with regard to the application and applicability of existing international law in cyberspace. The third is confidence building measures, and the fourth is capacity building. This is where we were in 2008 and 18, when the General Assembly adopted 2 new resolutions and established in parallel 2 new processes. Another one of the GGEs, number 6, plus for the first time an open-ended working group on the same issue. Open-ended meaning all 193 member states would participate in this discussion. Between the 2 processes, there are commonalities and there are also important differences. As I mentioned, both of them were established about the same time in December 2018, coming out of first committee resolutions and then being adopted by the General Assembly. Both of these processes are supposed to build on what has been done in the past. So the work that has been done by the GGEs from 98 to 18 is our starting point. The open-ended working group, as I said, is for the first time a dedicated process on the impact of ICTs on peace and security, open to all member states, all 193. Our mandate says we need to report to UNGA 75, so we have only a few months left to come up with our report. We were originally supposed to finish our work in June of last year, and I'll come back to that in a minute. The group of governmental experts that was established also in December 2018 has 25 experts this time. That's a bit more than the previous groups. And it also has mandated consultations with regional organizations, so it's a bit more inclusive also as in the past. It will submit their report to the General Assembly, the 76th General Assembly, so it has a bit more time than we have. The mandates are very similar. Ours, the Open-Ended Working Group, is more like a report on our discussion plus some recommendations to the General Assembly. The GGE is probably more going into details, more focused on actually coming up with new solutions, new recommendations. Plus there is one important difference. We have an additional agenda item in addition to the 4 I mentioned before. We also should come up with a discussion, or have a discussion and come up with recommendations on regular institutional dialogue, meaning on how we're going to deal with this issue in the future. What have we done so far since we started? We had 2 substantive sessions in September 19 and in February of last year. We had a very large, excellent intersessional meeting in December 2019. Multi-stakeholder, member states, private sector, non-governmental organizations, academia, etc. An excellent meeting, and also a new format in relation to cyber technology, new for the UN at least. And in all of these 3 meetings, what we have seen was a very high level of participation. Maybe not 193, but many of the 193 member states actually being in the room. 70 plus member states taking the floor each time, member states from all of the regions, very keen interest also from non-state stakeholders, which really reflect the importance of the issue, but also the urgency of the issue. So a lot of interest, a lot of engagement. We were, as I said, we were supposed to finish in June last year. This, of course, then due to the COVID pandemic didn't work out. We had to adapt our work plan. We switched to virtual format. We had a number of virtual exchanges last year. We're going to continue this soon. And our last substantive session is now planned for the 2nd week of March, 8 to 12 March. In New York. This will still be complicated, but so far the planning is going on. I suppose we can actually, in a limited format, but we will meet and conclude our work in March in New York. What's the way forward between now and then? I have issued a 0 draft of our report that will be the basis of our negotiations or discussions in March. The draft, for those of you who are interested, is accessible on our website, which can be accessed through UNODA. And we have another round in February to listen to member states, hear their reactions on the 0 draft and find out where are the areas we need more discussion, we need to work more because there are still differences of view, we don't have consensus yet. And then, as I said, the 3rd and final session in March in New York. beyond the simply procedural, how do I see our process going? You know, I've been optimistic throughout our process, not least thanks to or due to the very high level of interest, seeing so many member states participating in these discussions, explaining how important the issue is for them, how much they need this platform to come together to exchange and address the issues. So the will to come together is very clear. However, this is, as we all know, a complicated, complex issue, and we all know that the political environment is not less complicated. At this point, I see three main areas where we still have large diversities of views, three sort of fault lines. The first one concerns the norms of responsible state behavior. There is a bit of a discussion between a set of 11 and a set of 13 norms. Nobody really seems to question the need for improved implementation of the existing 11 norms as they have been developed by the GGE. There is also, I think, a rather large understanding that there may be the need to add some new norms. Some states, however, question the validity of these 11 norms. They say we have not been part of the discussion in the GGE, although these reports, the consensus reports by GGE, had later been adopted by the General Assembly. They maintain they feel less obliged and less bound by these norms because they have not been part of the development. Some states also insist on a set of 13 norms that was included in the General Assembly resolution which established our open-ended working group, whereas other states again find the 13 norms have not the same value because the General Assembly resolution that established our working group was not adopted by consensus. So this is one area where we have a diversity view still. The second one is international law. The first question concerning the applicability of existing international law. Some member states are at this point not ready to agree that existing international law, including relevant provisions of the UN Charter and the International Humanitarian Law, applies to the use of ICTs in the context of international security, a point of view that is not acceptable for other member states. The second question related to international law concerns the need for legally binding norms. Some member states insist on the need for an international legal instrument, a new international treaty, whereas others want to focus on improved implementation of existing international law. The third area, the third fault line, concerns regular institutional dialogue, how to continue the discussion on this issue. Basically, I don't feel that anybody questions the need for further discussions in an open-ended, UN-based format. But then how exactly to go about this, there is not yet consensus. You may also have heard that last December the General Assembly adopted another resolution already establishing a new open-ended working group with a time frame of 5 years that would follow this one. So this is a bit of a precedent. Meanwhile, some states are not happy about this new open-ended working group. At least not in the way it is described in the General Assembly resolution. Others came forward with the idea of a program of action as that should be at the center of the discussions in the future. Not yet clear how everybody supports that. So in this area, we have more discussions to do as well. So let me conclude, and I'm sorry for taking a bit long already, but let me conclude by pointing out why I believe these processes, both the GGE and the open-ended working group are really significant. They may not be able at this point to produce norms and mechanisms that will suppress the malicious use of ICTs and contain ICT's threat to international peace and security. Not immediately anyway. But what they succeed to do is they raise global awareness of the issue, and as they say, the first step is realizing you have a problem. They bring together a wide range of actors and a wide range of expertise, and they are able to provide further steps, maybe small, but at least some progress in the right direction, that is to better understand and reduce the risks through norm setting, confidence building measures, and capacity building. If we fail these two processes, if we don't come to consensus reports, I believe we will lose precious time in the race against a very significant and very real threat that concerns every single country around the world. And it also means one more example, and I'm not happy to say this, I'm sad to say this, one more example where we fail at prevention and will eventually come to regret it because we will pay a much higher price later. So, in spite of everything, in spite of this being complicated, in spite of we still having very hard discussions ahead of us, and in light of the importance of the issue, and because I believe that many, if not everybody, understands this is important and urgent, I remain optimistic that we will come together in March in New York and find a consensus around the report, a few recommendations, and build thus also a basis for the future discussion of the issue. Thank you very much, Heli. Thanks for giving me the opportunity to address your audience, among which I know are some of the key people for our discussion now or in the future with on this important issue. Thank you very much, and to all of you, have a great time in this wonderful course.
Thank you, Ambassador Lauber, for offering us an overview of the discussions in the open-ended working group. And I wish you all the strength in your efforts to chair those complex discussions. And just I'd like to let you know that Estonia always supports you. Thank you.
Thank you very much. Thanks.
Now, if you let me continue with our program today, we will have the first panel on international law starting soon. But before we start with the panel, I would like to remind you that you can ask questions from all the panelists on Workshop platform, which you should have in your device connected to our live streaming channel. The first panel on international law is a continuation of yesterday's discussion. When you remember, Dr. Lewis was laying out the difficulties of understanding the landscape of state behavior in cyberspace and how the norms of responsible state behavior, international law, and confidence building measures are the three elements shaping the global cyber stability framework, which we are now implementing. International law is one of the major and most important elements in this framework. So therefore, the discussions, analysis, and case studies on international law and how we apply it and the different interpretations of international law become more and more important as we go along with those issues. Not just in the United Nations context, but in the context of international peace and security in general, also in the regional context, in bilateral context, everywhere we are looking at the state behavior, we know that international law is creating the ramifications and is guiding the conduct of states in this space. And I'm very glad to welcome here a panel of experts, which I believe are truly knowledgeable and also geographically dispersed, as we try to invite different views, and also not just government representatives, but experts from academia and international institutions. So the panel will be chaired by my very good colleague, Erkki Kodar, who is right now Undersecretary for Legal and Consular Affairs at the Estonian Ministry of Foreign Affairs. Previously, he was working for the Estonian Ministry of Defense as the Undersecretary for Legal and Administrative Affairs, and also in the legal department and in the NATO department. We are also happy to have Dr. Anna-Maria Osula with us today. She's a senior researcher at the Tallinn University of Technology and also works for our homegrown company, CarTime. And previously, she served as a legal researcher at the NATO Cooperative Cyber Defense Center of Excellence here in Tallinn. Then we have Catherine Lotrionte, who is a senior researcher at Georgetown University and is internationally recognized expert on international law and cyber conflict, has testified before Congress, the US Congress, I believe, and NATO on cyber issues. She has authored numerous publications and books on this topic. And finally, we have Dr. Kubo Mačak as a legal advisor to the International Committee of Red Cross. And Kubo, prior to joining the ICRC, was also working at the University of Exeter in the United Kingdom as an associate professor. Kubo has taught and researched the area of international law, humanitarian law, and public international law, and is author of several books and articles. And without further ado, Erkki, the floor is yours. I don't know whether the cameras are here reflecting that we are actually standing in the same room with Erkki, but at least the other Estonians I could invite to join me. Please, Erkki.
Thank you, Heli. Well, first of all, this is a very distinguished panel. So we have a very good mix of academia and private sector experience, and very happy to see that we have a view from the main actor as well, the International Committee of the Red Cross. Of course, I feel undereducated because everybody else has a title that has a doctor or PhD in there in front of the names. But nevertheless, if we have a cyber medical emergency, some people are more well qualified than me to answer those emergencies. I will set the context of the session in that way that I will do a brief introduction of different processes that we need to be mindful today. But at the same time, I think we have a very good, let's say, a possibility to find different avenues and interesting segments of what's happening with international law regarding cyber. I think we will tackle today, first and foremost, what are the most important topics and discussions among lawyers on the applicability of international law in cyberspace. Seems like an easy topic, but I think the panelists would show that it's not that clear-cut. Also, how does international customary law and general principles apply into this picture? What are the different nuances there? What is international humanitarian law? Because not all of us might not know what it is, and how does it apply? And I think the most important or the most exciting would be to see where the agreements are made. What do we agree upon? And where are the points of disagreement? And that should be very interesting to see where we can agree and where we can disagree. But I will do a chair introduction in the sense that I will look into the UN processes briefly and then look into the national statements that different states have made on applicability of international law in cyberspace, and end with academic efforts that we need to be mindful and also see that how they help states and international organizations as well. And in that sense, starting with the UN processes, we just got a very good keynote introduction by the Open-Ended Working Group. And it is no secret that international law has been one of the most compelling issues in international organizations, as well as on national levels, for the last decade or even more so. As you have heard yesterday by many speakers, one of the main bodies of discussions that the international legal issues have been discussed is at the UNGG, the group of governmental experts. As with the UN, there are many acronyms today, so I'm sorry to use those, but I'll try to also open what they actually mean. But the GGE has addressed international law since the beginning of the last decade, and what we see is that there are various views on how international rights and obligations should be addressed in various forums, as well as in various situations in cyberspace. At the same time, one of the most important conclusions regarding international law has been achieved in 2012 and 2013, and 2014 and 2015 GG sessions, which agreed that international law and the United Nations Charter in particular apply in cyberspace. This has been the core value or the core statement of ongoing processes as well. The key element of these processes lie in the fact that these consensus reports, the outcome document of the GG, have been approved by the United Nations General Assembly. This means that we have all agreed with the international cyber stability framework created by the United Nations, alongside with the norms of responsible state behavior, capacity building, and confidence building measures. In addition to the general agreement that international law, and in particular the Charter, applies, the report also reflected that state sovereignty and international norms and principles that flow from it apply to state conduct on ICT-related activities and to the jurisdiction over ICT infrastructure within their territory. Regarding the report, states must meet their international obligations regarding international wrongful acts attributable to them. So far, so good, because this is almost like the 101 of public international law. But when we move into the future GG sessions, I would say that things get much more complex and difficult. These positions, nevertheless, were confirmed during the fourth GG, and the report added critical infrastructure-specific norms under the norms that apply for responsible state behavior. So the move has been always with the GG to find more norms or at least legal principles that guide responsible state behavior. Under the topic on how international law applies, the group of governmental experts further added that it is vital to bring forward topics such as in their use of ICTs that states maintain their sovereign equality. When international disputes should arise, states should settle them by peaceful means. Certainly, as in other areas, states should refrain from threat or use of force, and human rights and fundamental freedoms are to be respected. Finally, mentioning that states should also consider the principle of non-intervention in the internal affairs of other states as paramount. And finally, the GG also addressed the topic of attribution, which has gained a lot of momentum during the past 3 or 4 years. Attribution regarding internationally wrongful acts should be substantiated. Very good. Attribution has been one of the issues that has gotten much more attention in the recent years, as well as much more publicity, because I think for the last 2 years there has been also a proliferation of attribution efforts, which is interesting to see also how our today's panelists react to those efforts as well. But currently, there is the ongoing 6th GG taking place, which would finish in spring 21, which also discusses among 25 experts the topic of international law. In 2018, there was another group established alongside with the GG, and we were just briefed upon it, the Open-Ended Working Group, the OWG. And this is a state-level discussion group offering all UN member states the option to partake in international law discussion. A little while back, there was the first Open-Ended Working Group Zero Draft published, which of course, among other areas, addresses international law. The initial draft offers a rather wide array of views addressed by member states during the meetings. Similarly, this group should also finish the work during this spring. And in fall 2020, additional Open-Ended Working Group was established for the next 5 years, which also includes international law in its mandate. And in addition, France and Egypt, alongside with many other states, proposed a new idea called the Programme of Action. This would tie the 2 parallel processes back together under one line of work. So as we see, the UN has taken a very keen interest in the topic of how international law and cyberspace influence each other, and how does international actually apply in cyberspace. But at the same time, if we look how the GG has been there for the last decade or so, and even more, And there's a new forum beside it that also shows that there is something else in the room. There's some kind of an elephant that needs to be addressed in multiple forums as well. Secondly, I would like to focus on the national statements that have been proliferated as well during the last decade or so. In addition to the UN processes, there have also been states presenting their own views on how they see international law applies in cyberspace. This has been a welcomed approach, which would help to lay a groundwork on a future discussion, on a future agreement between the states. And also shows a level of complexity in the state's own understanding of how international law applies, because the states take a stance on different international law issues and principles and show their commitment that they are willing to abide by them, which is a very difficult step as well in this gray area. And for example, the US, the UK, Netherlands, France, New Zealand, Australia, Finland, Estonia, Iraq, and several other active states have presented their views on how international law applies in cyberspace. And states have addressed these issues ranging from sovereignty to the principle of non-intervention, peaceful settlement of disputes, countermeasures, threat or use of force, and also the inherent right of self-defense, which actually make a very crucial element of international law that the states in their day-to-day dealings apply. In this regard, from the Estonian perspective, we very much welcome this effort by the states to explain their views on vital international law topics, as we have done ourselves as well. And we see that these discussions have a strong value in the perspective of maintaining international peace and security, where international law undoubtedly plays a very important role. But there are other actors as well in this picture, other than the international organizations and the nation states, but also the academia. And last but not least, I would like to now touch upon the topic of the high value of academic research done on how international law applies in cyberspace. I'm very glad to bring forward processes of the Tallinn manuals, for example. And as many of you surely are aware, here in Tallinn, Estonia, we're hosting the NATO Cooperative Cyber Defense Center of Excellence, which we actually call just shortly NATO CCDCOE. And one of the flagship projects by this entity has been the Tallinn Manual project. There have been two publications, the Tallinn Manual 1.0, which focused on international law applicable to cyber warfare, and the subsequent Tallinn Manual 2.0, which focuses on international law applicable to cyber operations in a much more broader setting. Both manuals are one of the most comprehensive academic analysis on how international law could be interpreted in the context of state behavior in cyberspace. It is a work of academics and also experts. It is not binding any NATO member state or the member states of the CCDCOE, but it's a welcome step forward into seeing of what and how should we approach the Lex Lata in this regard. And I'm also glad to mention that CCDCOE has started the process of Tallinn Manual 3.0. This has been launched, which gives academics and states, again, a new avenue to contribute further on how processes have been taking place during the past year and past years' influence of what we actually put down into paper in Tallinn Manual 2.0. We also welcome the participation of civil society during the open-ended working group meetings, and it is good to see that how the academic efforts are also getting more traction, not only in an academic setting, but also being used in an international setting as well. So in conclusion, this is the scene, but there is much more to be taken into account of and much more to be zoomed in on. And now I would like to give the floor to our speakers, who will introduce the main topics regarding international law. As you will hear, legal principles varying from the below the threshold activities to the international humanitarian law. So I think we will cover the whole spectrum. And I would like to give the floor first over to Anna-Maria Osula. And especially with your background in the private sector, government and academia, you would be the ideal person to set the scene on the most important discussions among the lawyers on the applicability of international law in cyberspace. So the floor is yours, Anna-Maria, please.
Thank you very much, Erkki, for this introduction. I'm grateful for the Minister of Foreign Affairs for inviting me. I'm sorry that I couldn't be there with Erkki and Heli in the rooms of the Minister of Foreign Affairs, but I can confirm that also in other parts of Tallinn, it's truly winter wonderland outside, and so it's great weather for a winter school on cyber diplomacy. I would also like to congratulate the Estonian Minister of Foreign Affairs for taking up the task of raising awareness, because I think these issues are really relevant, and especially for the diplomatic community, it is important to have venues such as these to broaden the horizons and discuss different topics. I was asked by the MFA to set the scene on the most important discussions ongoing regarding international law and state behavior in cyberspace. And in order to offer context for today's discussions, I will first say a few words about international law in general. Then I will outline some of the main issues for debate at the international fora, but I will not go too much into detail in order to allow my co-panelists who will be speaking after me to offer more insights into some of these topics. Finally, similarly to Erkki, I will underline the relevance of expressing domestic views in order to reach greater clarity on how international law applies. Indeed, international law plays a central role in the discussions on state behavior. And rightly so, because simply put, international law regulates the behavior of states and is made by the states. And in many ways, international law is the foundation for stability and predictability in relations between states. And like Erkki mentioned, cyber stability, then I think international law has a great role to play in reaching this stability. We find international law in treaties, customary law, which is formed by state practice, also general principles of law, jurisprudence, and scholarly writings. When we talk about international law and cyberspace, then we usually divide the legal aspects into two parts, jus ad bellum and jus in bello. Jus ad bellum is the legal framework for using force and also regulating the operations that fall below the threshold of the use of force. And jus in bello, or in other words, law of armed conflict or international humanitarian law, regulates then states' behavior in an armed conflict. However, I would also want to mention as a side note that most of the cyber incidents we are witnessing around us today can actually be classified as cybercrime and are conducted by non-state actors, and thus addressed, for example, by domestic penal codes. But international law remains central when we talk about the behavior of states and when we talk about cyber operations that can be attributable to states. And as pointed out yesterday, international law is the foundation of and the framework for the voluntary norms agreed on regional and international fora. Hence, the interconnection of norms and international law and norms, I mean here, politically binding norms and international law is really relevant. Thank you for Ambassador Lauber for the introduction. I believe that the open-ended working group's zero draft is a great document to reflect the current debates on international law at the UN level. I also believe that it is really relevant to give states the platform to express their views and concerns. As we heard from Ambassador Lauber, and as we have seen in different discussions, then there are states who are concerned that they have not been part of the UNGG or the limited group of countries agreeing the norms. And I think it's actually quite important what Ambassador Lauber said, that some states are saying that they are not ready to agree that international law applies because they were not part of the group that wrote or put together the UNGG report. So I think we can say that so-called the like-minded states have, of course, all agreed that international law applies. We have adopted the reports. It has been approved by the GA, etc. But we still need to pay attention also to the voices claiming their concerns. And we have an example of a similar approach actually from the Council of Europe Convention of Cybercrime. It is a very important document when we talk about setting standards for what acts can be classified as cybercrime, what are the responses, what are the principles for cooperation, etc. And still there are states who are saying that they are not, and this is one of their arguments, that they are not signing the document because they were not part of the group of states that was originally negotiating the treaty. Nevertheless, I think it is still fair to say that there is broad agreement that international law, namely the UN Charter, applies to state behavior in cyberspace. And hence, the focus of the discussions regarding international law is mostly on how it applies. There are actors concerned by the militarization of cyberspace and hence have issues regarding the applicability of international humanitarian law to state behavior in cyberspace. And they follow this position even though the principles of IHL were outlined clearly in the UNG 2015 report. The Zero report that Ambassador Lauber introduced really nicely highlights also other international law questions which are yet to be fully clarified. Of course, here I have to agree with what Erkki said, that there are so many legal issues and many of them are so multi-layered that we can only, in this panel, touch upon a selection of these. So, of course, there are further issues that should be clarified, but the main issues include the following. For example, a threat or use of force, as outlined in Article 2.4 of the Charter. So there is a general consensus that cyber operations that cause significant injury, threat, or physical damage qualify as use of force. However, the open question is whether cyber operations that do not bring along injuries or physical destruction, but, for example, constitute loss of functionality, whether these operations can reach the legal threshold of the use of force. Related issues pertain to state responses to cyber operations. For example, when a state is invoking its inherent right to self-defense, Article 51 of the Charter, whether it is allowed to respond to it by all means, including also the traditional military options. There are different views on this. Another topic that is really interesting, but I think an extraordinarily complex one is, of course, sovereignty. There is a lot of debate regarding the balance between sovereign rights and international commitments, and Dr. Lewis yesterday outlined these issues quite clearly. But also for a while, there has been a debate regarding whether sovereignty should be considered as a standalone rule or a principle under international law. Right now, we can say that there is not much active debate about it, as the majority of those who have expressed their views agree that sovereignty is a rule of international law. However, the UK differs on this and believes that sovereignty should be regarded as a principle. Some states have clearly pointed out that it is important to classify sovereignty as a standalone rule because in that instance, the breach of the rule would allow the victim state to resort to countermeasures. And this is an important protection mechanism. Another question regarding sovereignty relates to the threshold of sovereignty, breach of sovereignty. So when can we say that an operation has been breaching the rule of sovereignty? Let me give you an example. Imagine that there is a cyber operation conducted remotely into other states' territory, for example, for the purposes of accessing and/or copying data. Would this operation amount as a breach of sovereignty? Again, I will not offer any surprises for you. There are different views in this regard. What is, I think, relevant to underline regarding the issues I have just raised is that these issues are not new. They have been discussed for quite some time. And as suggested yesterday by Dr. Lewis in his speech, then it remains unclear whether these viewpoints can be brought together in the near future, because as he described, then these different opinions are only being more refined and becoming more solid. But this really brings me to my next point, which is that we shouldn't be afraid of international law. International law is not a fixed constant. It evolves with time, and it can develop progressively, including through opinio juris and state practice. And of course, it takes time. Therefore, it must be underlined that an important source for understanding how international law applies to cyberspace can be found in national documents, and especially in states' descriptions on how they have interpreted international law. These can be in different formats, for example, annexes to the UNGG reports as part of domestic cybersecurity strategies or separately published views. As echoed before, it is great to see that there are more and more states adopting their views, recently, for example, by New Zealand. And Estonians always love their presidents. And there is a famous quote by Lennart Meri, who was the first post-Cold War president of Estonia. And he was saying that international law is the nuclear weapon of small states. So this is why Estonia specifically believes that international law is offering great protection, and more clarity regarding how international law applies is really relevant. Also, to quote our current president, Miss Kersti Kaljulaid, then she said that Estonians don't have the luxury of not publishing their views on international law. And I think this applies perhaps up to debate, but perhaps even more to smaller states. But needless to say, the decisions to publish a national view are clearly strategic. So is the content of the interpretation in those documents. There are those who believe that normative ambiguity is offering advantages, and those who believe that the so-called grey zone of this unregulated legal area is dangerous. At the same time, given the general lack of state practice, it is understandable that states are cautious and want to approach the legal assessment case by case. In any case, agreeing on a domestic view is a great exercise. If you haven't done it in your country, I suggest you to try. So states should certainly be more active in their views regarding international law, and not only publishing their domestic view or simply condemning cyber operations in general, but also calling out when cyber operations are violating international law. Only like this we can have more clarity regarding where is the so-called red line when an operation is wrongful under international law. Today, often states are admitting the existence of certain rules, but hesitant in offering more detailed interpretation. And equally important, of course, are different exchanges between states in different fora. Already the exchanges themselves are great for cooperation and confidence building. A lot of progress has been made on regional fora, and there are different establishments and different frameworks for facilitating such discussions. For example, the European Union adopted in December 2020 its cybersecurity strategy for the digital decade, where it expressed its concern regarding, I quote, the deterioration of an effective multilateral debate on international security in cyberspace, and declared that it will develop a common view on the applicability of international law amongst its member states. And I think this is a really great example of a regional organization using its leverage to encourage its member states to adopt such views. A similar common voice of the EU is also clearly seen in the proposal for the Programme of Action to advance responsible state behaviour in cyberspace that was mentioned earlier. And in addition to what I have mentioned above, I really believe that the 1.5 track discussions with different stakeholders are relevant because, as I said before, and as was mentioned by several speakers yesterday and also in the opening for remarks of today, then there is a great appetite not only from different states in expressing their views, but also the wider multi-stakeholder community, including NGOs, academia, and the private sector. Thank you very much. These were my remarks today. I'm looking forward to the discussion and the questions.
Thank you, Anna-Maria. There was a lot to take in from there, and of course this is a good time to remind everybody that we also have an interface where you can actually submit your questions or remarks for the panel at the Worksup platform. So please use that, otherwise I will use the chair's prerogative to ask any questions that interest me. But moving on, let's give the whole panel a chance to represent their views and have a thorough picture before us, before we go to the questions and the answers period. I will now move over to Catherine. Maybe you could offer us an overview on the major elements of customary international law that frame the state behavior below the threshold of armed conflict, and also go into much more detail on, let's say, the different general principles that are being used in public international law as well, and maybe touch upon certain possible response options like countermeasures, self-defense, plea of necessity, because I would think that would take the topic much more deeper, where we now have started with me and Anna-Maria. So Catherine, please.
Thank you. Thank you very much for having me. Welcome everybody to the course, everybody who's watching. I'm glad that we've got a lot of interest in the topic because, as many prior speakers have noted, it's an important issue. This is one of my favorite topics to talk about, that being customary international law related to cyber and the use of cyber, particularly customary international law below the armed conflict threshold, what Anna referred to as use ad bellum. So I will try to cover as much as I can in the time without going over. We hopefully will revisit some of the issues in the questions because there is, I usually take about half a semester actually in teaching international law to my undergrad students just to cover this topic. So I will try to squeeze it all in the time I've been given. But hopefully we'll revisit some of the details. So first I want to point out what I think is really important is to note the difference between what is the words commonly used, norms versus law. So as a lawyer, but also somebody who studied international relations and was a constructivist working on norms, I can understand and appreciate not only the relevance of both norms and law, but the importance of being clear about how they are different. So when we speak about norms, and often and in the GG reports, they're categorized as norms, rules, and principles. These are non-binding commitments. So they're expectations of behavior, but they're non-binding as a matter of law. When I'm speaking about law, I'm only going to be talking about international law, which is binding. So hopefully we can kind of set that. I was happy to see in the new Zero draft by the OEWG that came out last month, they made it very clear, and I'll just read quickly the statement. States agreed that norms do not replace or alter states' obligations under international law, which are binding. So there can be a bit of confusion when we take a legal principle and we put it in a document or in discussions when we refer to it as a norm, because some might be then wondering whether it's legally binding or not. There are norms that eventually develop into law, but not always. The norms that are in the GG reports also contain some examples of principles that are also legally binding. So hopefully we can get into that in Q&A. But to get into some of the details, I wanted to point out some of the recent claims, more recent claims by states. Luckily, we are seeing some states that are coming out and identifying actions by other states that they believe are violations of international law. For years, we didn't see any of this. While we can criticize that the accusations are still not detailed, meaning from a lawyer's point of view, I would love to see a very detailed description of what parts of what specific rules of international law are violated, but at least we're starting to see states claim that other states are violating law. Quick examples, 2018, the UK accused Russia of flagrant violations of international law. That was with respect to carrying out cyber campaigns against transport systems in the Ukraine. In 2020, the UK again, as well as others, came out and accused Russia of the cyber operations against Georgia. That knocked out TV stations and numerous government websites. We're also seeing, though, an indication that states are starting to indicate what they believe would be a violation of law versus what they would not believe to be a violation of international law. For instance, in 2014, when North Korea conducted the cyber operations against Sony, the US government, President Obama, referred to that as an act of cyber vandalism. So, not referring to international law at all. In 2018, with respect to the Iranian campaign against universities and other companies, the US and the UK declared those activities, declined totally from declaring they were in violation of international law. And then another major cyber incident of WannaCry in 2017, that was a ransomware operation. The UK referred to that cyber incident as a criminal use of cyberspace. So we are starting to see, and I think it's a positive step, states kind of taking the initiative, maybe not in describing their own activities within the context of international law, but starting to call out other country activities that they believe may or may not be in violation of international law. And that is what academics and scholars typically look for when they're looking to discuss and identify the development of customary international law with respect to cyber operations. I'm going to skip forward and try to get to some specifics. There are a number of relevant parts of the Zero draft report from the last month of the OEWG that I would refer to everybody to look at, because it's got some updated since the last draft, mentioning particularly for customary international law. I was happy to see that they included the two elements required for customary law to be law, and that is both state practice and opinio juris. So we know that international law can be developed in two main ways. Well, if you consider, arguably we say three, but the easiestly understood are treaties and custom. And I say that with some pause because custom is not so readily obvious to people in terms of when it is law. But treaties, obviously, states are signing similar to a contract and agreeing to certain terms. In custom, you will have to have state practice. Now, the International Court of Justice does give us some insight as to what practice means. Practice, it is a particular kind of practice. It has to be by a majority of states, no exact number. It's got to be pretty consistent, although doesn't have to be perfectly consistent. And although many states have to be conducting the practice, it doesn't necessarily have to be universal. In other words, there can be regional customary law developed among countries, of which would be whatever the issue is would be relevant for those countries. So we have the practice, but we also have opinio juris. And this is what becomes a challenge, particularly when it comes to cyber, but even in other areas of state activities, because states often, so opinio juris is the belief that the practice that you're engaging in, or it could also be a lack of practice that is considered practice. The opinio juris is the belief that that practice is legally obligatory. So now the way that you would determine whether a state is actually conducting a practice that it believes to be an legal obligation and therefore making it law, if it is developed by other states, is to look at both statements of government officials. You can also look at written government documents. Court decisions can be insightful, the domestic court decisions. So there are a number of ways that scholars, academics, when they're researching customary international law, you will look to what the state says and what the state does with respect to identifying the development of customary international law. Now, importantly, and I think relevant in the context of what's going on in the cyber discussions, there is the principle of an objective, a persistent objector under international law. With respect to customary international law, if there is a custom that is developing and in the process of developing, and if a state persistently and publicly objects to that development, then once that custom becomes a universally accepted legal requirement, that persistent objector will not be bound by that law. Now, that's important because if we see countries within the GGE or otherwise persistently objecting in a public way to a potentially developing principle of customary law, they may have the status of a persistent objector, even when that law becomes accepted as universally binding. So that is hopefully, if I could go past customary law and skip to some of the legal principles that were discussed and brought up. Let me start with the principle of sovereignty. Without a doubt, sovereignty is a fundamental principle of international law. It is basically, if you think of it, it is the foundation or basement in which other principles of international law stem from. And so from the International Court of Justice, we have the specific definition of sovereignty, and it has both an external element and an internal element. But sovereignty basically means that a state is actually, one, equal to other states, and also independent in the sense of it has the ability to control within its own territory, and in certain actions outside its territory, that state's own decisions and actions. Now, within the GGE and even within the open-ended working group, we have had repeated a reference to state sovereignty and the importance of it, and sovereign equality. Now, to be honest with you, those words alone don't tell you much. When we say sovereign equality, it is kind of difficult to identify what is the meaning of those words in the context of any document. But I'll give you some examples of what traditionally has been expressed by states in the past as violations of sovereignty. So for instance, US or for any government official airplane flying without consent into the airspace of another, over another country's territory has been by states called a violation of their sovereignty. In that case, it would be their territorial sovereignty. Now, activities that are not considered violations, which are often more important to consider in thinking about cyber activities that have not been considered violations of sovereignty, are things like propaganda and criticizing another state's policies. Those would not be considered violations of sovereignty today. In the past, of course, historically, we have had states argue that criticizing their policies may violate their sovereignty, but generally accepted that is not a violation of a state's sovereignty. Now, Anna pointed out an important and still controversial topic related to sovereignty. It has come up in the context of cyber. Interestingly enough, this has not come up previously. When we talk about international law, this specific debate has not been raised in other areas of international law. So it's unique in some sense to the cyber discussions. And that is, how do you apply the principle of sovereignty to cyber? And the debate is between, as Anna mentioned, considering sovereignty as a rule versus sovereignty as a general principle. Now, sovereignty as a rule would say you can violate this rule in and of itself without having to violate any other rules that we'll talk about, but you can violate this rule, and when you violate it, it constitutes an international wrongful act, and therefore, importantly, the state that's violating this rule can be held responsible under international law. Now, a number of states have come out and announced that they support this view of a rule. That would be Finland, the Netherlands, Switzerland, the Shanghai Cooperation Organization. Now, a minority so far, because we haven't heard from all states, take a position, and I would put 2 countries so far in this category as sovereignty only as a general principle, which means that it is not a standalone rule that can be violated in and of itself. That sovereignty as a general principle, it's fundamental, but from this principle, you have other rules of international law that is derived. And I'm going to speak about 3. There are generally accepted 3, what is called derivative principles of sovereignty: due diligence, prohibition against intervention, and prohibition against the use of force. Now, the 2 states that have taken this secondary view as a general principle, explicitly, the UK has taken the position, and not so explicitly, but if you read the statements and listen to the statements made by, for instance, Department of Defense's General Counsel last year and other US government officials, you can read between the lines, and they've implied that they are with the UK in interpreting the principle of sovereignty. But there hasn't been an explicit, formal, very clear statement made by the US. But if you read the state, there was a discussion by the General Counsel of DOD last year, and he seemed to indicate in his speech that he was sympathetic to, and I think he used the word sympathetic to, the UK's position. So quickly, onto the derivative principles. There are these important principles relevant for cyber. I will highlight them and try to highlight what countries have, within the cyber context, have signed up or said, yes, we believe that this principle is reflective in cyber operations. So first, there's this principle of due diligence. It has been mentioned in the GGE report of 2015. Interestingly enough, they put this principle under the norm section, and they use the words indicating that, unlike when they refer to the law, where the authors use the words must, they use the words should, indicating, and that's why it would be under the norm section and not the international law. But this principle says that states have an obligation to ensure that no harm emanates from their territory, violating the rights of another state. Now, there's important elements of this obligation. One, that doesn't mean that you have to, a state is obligated to prevent all harm, but you have to take certain reasonable measures to prevent that. And also, another important element of the definition is you have to have knowledge. So if a state doesn't have knowledge of any harm emanating, then they're not going to be held in violation of this due diligence obligation. Now, the states that have signed up to this obligation explicitly: Estonia, Finland, France, Brazil, and Netherlands, in the context of cyber. The prohibition against intervention, again, these are all customary international law, not within a treaty, but have been referenced at times within General Assembly resolutions, including with cyber discussions, as well as by the International Court. But the prohibition against intervention says that a state cannot interfere in the internal affairs of another country. And that really, as it's referred to as a derivative principle of sovereignty, that comes from that principle of sovereignty, that a state has sovereign rights within its own territory and its own activities. Now, there are 2 important elements of an intervention that are necessary in order for an intervention to be illegal. One, it has the state conducting the intervention has to have the intent to coerce. So the intent of doing the intervention is to coerce the state to make a choice, or to not, to either do something it didn't want to do, or to refrain from doing something that it wanted to. Secondly, to be an unlawful intervention, it has to, the intervention has to target a specific activity that the state has an independent right to decide freely, otherwise called under international law the domain of res ve. This has to do with political issues, economic issues, social and cultural issues, foreign policy decisions. So now to the prohibition on the use of force, and I'm going to try to go as quickly as possible. I'm not covering all the details. The use of force prohibition exists both under customary law, but also under treaty law. It is in Article 2.4 of the UN Charter. I was happy to see that the most recent zero draft report by the OEWG cited to Article 2.4 of the Charter, and also, interestingly enough, because it has never been cited in the UNGG reports, it did cite to Article 51. And I will only be touching upon that if I have time, but that is, of course, the armed attack reference in the UN Charter, giving states the right of self-defense if they've suffered an armed attack. Now, back to the prohibition of use of force in Article 2.4, without any definitions given in the UN Charter, but over the years, there's been a general acceptance by states. This is a binding, universal customary law that a state cannot use force, and the exact words in the Charter, against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the UN. There is general consensus in the cyber domain within the UNGG reports and also the open-ended working group draft reports that states seem all to agree that this is a binding rule in cyberspace, that states cannot use force. Now, there are a couple of exceptions, both in the UN Charter and in customary law, to the use of force prohibition. One, in the Charter, if the Security Council authorizes the use of force, that would apply in cyberspace as well. A second is the reference to Article 51 that I mentioned in the Charter. That article says that if a state suffers an armed attack, then they have the right to use force in self-defense. There's also the right, if a state has been given consent, of course, by another state to come in and defend them under Article 51. That also is a means in which another state could use force in self-defense in a collective manner. Okay, so that is Article 2.4. The context of the discussion in the cyber discussions, of course, is that there's no exact clarity on when a cyber operation would actually trigger that threshold of a use of force. Typically under international law, what has been accepted as a useful means is to look at the scale and effects of the activity. And from that, decide whether it has caused enough damage, physical destruction, or death to violate that prohibition. What is still remaining an open question, and Anna mentioned it, is can you have a use of force that produces no physical damage? So what if you're just compromising interconnectivity, network operations? Typical example is, what if the stock market is taken down without any physical damage? Well, typically under international law, when the charter was being negotiated and there was a discussion on what a use of force was, the members, and it was actually the Latin American countries, specifically said that economic effects were not considered uses of force. So, will we see a divergence in a new customary legal principle develop, where you can have economic effects being constituting as uses of force? There are some countries that have actually indicated that they would expect and be open to that. Now, before I run out of time, which I think I am, I'm going to speed through the use of force quickly to talk about general principle of state responsibility. So now, if you have a breach of an international legal obligation, what would be called an international wrongful act, then there are certain, if you will, ramifications that can come from that. In a body of law built on customary international law called the General Principles of State Responsibility, there are a number of categories in which states who have been a victim of a wrongful international act have now, I would call it justification, because their actions don't necessarily become legal, but they're justified in taking certain actions that would otherwise be constituted as illegal. But because they have suffered an international wrongful act, they are justified in taking those actions. Now, the ones that the International Law Commission has given us in the Articles of State Responsibility are, I'll give you a quick list. There is the ones that I was going to touch upon: countermeasures, There's self-defense, which I've also already mentioned in terms of the UN Charter. There is force majeure that I'm not going to talk about. There is distress, which I won't have time to talk about, but there's the plea of necessity. The two most relevant when it comes to international law with respect to cyber is countermeasures and the plea of necessity. I'm not sure I have enough time to go over those. I am just going to mention quickly. And please, if somebody wouldn't mind, just cut me off when I'm going way over. I'm going to skip the reasoning behind the principles, and I'm going to skip to countermeasures. Well, one important thing, and it was mentioned at the beginning, under these general principles of state responsibility, if you are going to hold another state responsible for a breach of an international obligation owed to a state, you need to attribute that wrongful act or violation of the law, you need to attribute it to the state actor. And the draft art or the articles of state responsibility go into much detail about what that means in terms of what is the threshold, what is the, if you will, the standard of evidence, which is generally accepted as clear and convincing when you need to attribute your act before you take a response, a legally justified response that would be in violation of law, except you're responding to a breach. Before you take that action, you need to attribute it. Now, one point, because it came up in the UNGG reports, and it's kind of a pet peeve that I have. As a lawyer, some lawyers have a lot of pet peeves because they're pretty anal, like serious about every detail, every word. When accusing a state of a wrongful act, there is no obligation under international law to substantiate those accusations. That's when you're merely accusing them. Now, that is not to say that if you take an act in response to that violation that you've suffered, that you won't be challenged later on, whether it's by the Security Council, whether it's by other countries, whether it's by the International Court of Justice, where you would have to justify that action. Clearly, then you would have to discuss how you attributed or how you were able to identify that state that you took the action against as responsible for the breach. But the UNGGE report does have within it this, I would call it a recommendation because it's not legally required, that states should substantiate these allegations. And I think that is a good recommendation. I think that is a safe recommendation, but I want to make clear that it is not legally required under international law. Countermeasures are one of the, if you would say, justified responses to a breach of an international obligation owed to a state. Countermeasures have a lot of procedural and substantive requirements in order to make them justified. So a countermeasure is an action that would be otherwise illegal, but for the prior breach that a state suffered, and you are justified in taking a countermeasure for the purpose of getting the other state to comply with their obligation. It cannot be in retaliation, or it cannot be for purposes of punitive punishment, and it cannot be escalatory. Countermeasures also have, as I mentioned, a number of substantive, if you will call them, limitations. And I don't know if I have time to go over them, but it ranges from when possible, notice must be given to the state in which you're going to take the countermeasure against. It cannot be a violation of Article 2.4 of the UN Charter, meaning a use of force for purposes of what the UN Charter Article 2.4 means. If feasible, your countermeasure must be reversible. Countermeasures cannot be anticipatory. And I think that's probably the hint that I'm running over. I did not get time to go to plea of necessity. Thank you for putting that screen back up. I will now cut myself off. I hope we have some really exciting and challenging questions that we can dig into. But thank you for your time.
Thank you, Catherine. I think you just elaborated on what actually lurks beneath the surface if you only scratch it. So everything that we previously have encountered here is that there's so much detail to go in when when one goes into much more finesse on these matters. But I would like to now give the floor to Kubo as well, because everything has now leading up to this moment. We have been the warm-up for Kubo Mačak. And we turn into the features of international humanitarian law and the law of war, and how does that fit into this applicability picture. So Kubo, the floor is yours.
Erkki, thank you very much for this kind introduction. And yeah, it's a pleasure to be on this panel. It's a pleasure to come back in a way to the winter school. I think I remember the very first one, which was a summer school, and it was still in person. And so it's a bit of a pity that we can't all be in one room and discuss these things together. But I think as a kind of plans B go, this is an excellent plan B. And so far it's gone really well. And I have been learning a lot by listening to my co-panelists. So today I was asked to lay out the main concepts of IHL, of international humanitarian law. So in the sense, looking at the subjects that the law is protecting and how IHL relates to cyber incidents. And so in preparing my presentation, I tried to take the perspective of the diplomatic community, or of a member of the diplomatic community. So if you are a cyber diplomat following this agenda, what are kind of the main things that you need to know about international humanitarian law? And so, because I am here representing the Icrc, the International Committee of the Red Cross, I'm also calling in from Geneva, similarly to Ambassador Lauber, I thought it makes sense to start by looking at what is the Icrc approach. And so, at the Icrc, we have over 2 decades of experience of looking at cyber operations. So it also dates back to around the time when the first UN General Assembly resolution on these matters came about, that was mentioned earlier. And so whether it's cyber capabilities, whether it's autonomous weapon systems, or any other new means and methods of warfare, the Icrc has the following approach, and it goes in 3 steps. So first, we follow the technological developments and what is their military potential. And then secondly, we assess the potential human cost of such technological developments. So taking these 2 together, we have, for example, in our research and in talking to experts, identified specific vulnerabilities that cyber capabilities pose, both during peacetime, but then, of course, many of them would be much more underscored or much more prominently faced in times of armed conflict. So to give an example, in a report that we published about 2 years ago, we highlighted that the healthcare sector is one of these specific vulnerabilities, and we explained reasons why by talking to technical experts. We also talked about how industrial control systems can be specifically vulnerable, such as those used to support water treatment facilities. And so during the pandemic, then sadly, we have seen many of these concerns confirmed. We have seen many cyber attacks against hospitals around the world. And just this week, we have heard about a cyber attack against the waste treatment facility, against the water treatment facility in the US. And so at the Icrc, we highlight the humanitarian costs that such cyber operations might pose. And then in the 3rd step, so understanding how the technology develops, how the militaries might be using it, seeing what the risks are, in the 3rd step, we work on clarifying and, if necessary, on developing the law. So not everything that we do is public-facing, but several things are. So I have mentioned these 2 reports. So one is the potential human cost of cyber operations report that we have already issued, and the other one looks at avoiding civilian harm during military cyber operations, which kind of comes under the 1st work stream and which we will be issuing later on this year. But then, as I said, mainly I'm a lawyer by background, so my perspective is very much a legal perspective, and that's also the work that we do. We focus on the 3rd prong, and that's the clarification and development of the law. So let's take it to that angle, and let's look at what we actually mean when we talk about applying IHL in cyberspace. Right? So the topic of the panel today is applying international law in cyberspace. So my focus now is on applying international humanitarian law in cyberspace. Now, when we break that down into smaller pieces, let's take it in reverse order. So when we talk about cyberspace, or about cyber in this context, for the Icrc, the focus is on cyber operations during armed conflicts. And what we understand under this term is essentially operations against computers, against networks, or any other devices of this kind that are conducted through a data stream when they are used as means and methods of warfare during an armed conflict. Then in the second step, what are we talking about applying? What is the legal framework? That's IHL. So as you have already heard from Anna Maria, international humanitarian law is a part of international law. And it's that part of international law that governs the conduct of belligerents during armed conflicts. And so it is also referred to as LOAC, the law of armed conflict. It can be referred to in Latin as the use in bello, but it is that part of international law. And that's a crucial insight, that it is a part of international law, which we will get to in just a moment. And so then finally, putting these elements together, when we talk about applying one to the other, what do we mean by that? And again, you have heard this already earlier from my co-panelists. There are the two questions, right? When we say that X applies to Y, there is the whether question. Does it really? Right? Does X really apply to Y? Does IHL really apply to cyberspace? And then in the second step, there is the how question. So, okay, if it applies, how does it apply specifically? What are the specific modalities? And so let me try to take you through these two questions in the remainder of my presentation. So first of all, we have the whether question. Now, Erkki already told us in the first, not the first, but in the 2013 GGE report, the GGE has come to a consensus that international law in general applies to, in the context of cyberspace. We can debate whether this consensus is 100% accepted around the world, but there is certainly a general agreement. So you would be forgiven by thinking, well, if international law applies, then IHL as a part of the whole should also apply. But there have been some opposition to this conclusion, or to this kind of logical inference. So I think it's useful to analyze this whether question in a little bit more detail. And so from the ICRC's perspective, it's also my personal view, the essential difference that we need to make is to distinguish between regulation and justification. And once that difference is made, the answer to the question, does IHL apply, almost follows automatically. And so what that means, this distinction between regulation and justification, is that when we say that the law governs a certain type of conduct, we are not saying that that type of conduct is in any way legitimated. And so to give you a very specific illustration of that, let's say that after this panel is over, you want to go get a cup of coffee. So you leave the building that you're in and you cross the street so that you come to the nearest coffee shop that's in front of the building. Now there is a traffic light that you need to kind of pass on the way there, and you see that the light is red. Your conduct is being regulated by the traffic rules. But are you being encouraged because these rules are in force, because you accept that these rules exist? Are you encouraged to cross the road on the red? Far from it. You are constrained in your behavior if you're a law-abiding and law-respecting individual, and you think, there is the red light, so I have to wait until the light turns to green, and then I can cross the street. And so if you think, well, that's maybe too much of a simplification, let's look then specifically at IHL as a body of law. And so we know in the next step that IHL is a body of restrictions, not of permissions. So in other words, international humanitarian law is prohibitive law, and it has been described as such in a host of case law dating all the way back to the subsequent Nuremberg trials. That's the US military tribunal in the hostages trial that you see on the slide. And then finally, IHL is a body of law that exists to regulate the wars of the future. That has been always accepted. We cannot regulate something that has happened in the past. So the norms that it contains, of course, react to things that happened in the past, but it is here to apply prospectively. And so this has been acknowledged by the International Court of Justice in the Nuclear Weapons Advisory Opinion, where it stated expressly that IHL applies to all forms of warfare and to all kinds of weapons, including those of the future. And so if cyber capabilities are such methods and means of warfare of the future, right, that came later than the relevant norms were adopted, that's not an obstacle to the application of these norms. Far from it. Actually, that's the reason why we have these rules. So what does that come to? That we answer this question in the affirmative, that IHL does apply to cyber operations. Well, I would say there are things that it does mean and things that it does not mean, right? So on the one hand, it means that IHL restricts the choice of means and methods of warfare, right? Just like it restricts what the pedestrians and cars can do outside in the street. So not IHL, but traffic rules, of course. In the same sense, IHL restricts the choice and the conduct that the belligerents have available to them. And then in the second step, because it does that, because it constrains what the parties to the conflicts may do, in doing so, it protects civilians and civilian objects. So that answers who are the subjects and objects that are being protected by this body of law. But on the other hand, IHL, in doing that, it does not legitimize cyber warfare, and it does not encourage the militarization of cyberspace. And so at the ICRC, we were very pleased to see language to that effect also in the draft, in the zero draft that Ambassador Lauber and several of my co-panelists have referred to. So if you're with me, and if you accept that the correct answer to the first question, to the whether question, is in the affirmative, that yes, indeed, IHL does apply to cyber operations, well, that doesn't answer all the questions. That just takes us over the necessary threshold. But then we start facing all of this plethora of how questions. And of course, we could be here until the end of the day. So let's just look at two such questions. And in doing that, I thought it would be useful to take one of these very fundamental rules of IHL. So this is the rule that we find in Article 52 of the first additional protocol to the Geneva Conventions. It is also a rule that is considered as customary, a rule of international humanitarian law. And that's a rule according to which direct attacks against civilian objects are prohibited. Now, nobody questions that this rule applies, that everybody accepts that this is a customary rule of IHL. The question is, if you accept that IHL applies to cyber operations, how does it apply to cyber operations? And it turns out that there are two terms where we need a little bit of interpretation and where the opinions actually diverge as to how these terms could be interpreted. And those are very key terms, basically almost all the substantive nouns that you have in this sentence. It's the term attacks and it's the term objects, right? So you could translate those controversial areas into how questions in the following way. You could ask, number one, how should the notion of attacks be interpreted in the cyber context? And number two, how should the notion of objects be interpreted in the cyber context? So let me give you an example so that it's not too abstract. So imagine that in the context of an international armed conflict, one of the belligerents decides to conduct a cyber operation that will bring down the network of the banking network on the territory of its adversary. So it will make it dysfunctional. The network will not operate anymore. And let's imagine a further operation in which the same belligerent decides to conduct a cyber operation, the effect of which will be to delete all social security data that's held by the civilian agency that organizes such data of its adversary, right? So one against the banking network, one against social security data. So let's start with the first of these questions. So what is, can a cyber operation amount to an attack? Now, the good news is that we have a definition under IHL. Article 49 of the first additional protocol defines attacks as acts of violence against the adversary, whether in offense or in defense. Now, there is a general agreement that this includes cyber operations that can be reasonably expected to cause injury, death to persons, or damage or destructions to objects. But the key question becomes, what qualifies as damage with regard to cyber operations? And we have two views, right? So simplifying the broad spectrum of views, we could identify two categories or two camps. One is the narrower view, which claims that only operations that cause death, injury, or physical damage, right? So physical damage, that an object that exists in the physical space is damaged, destroyed, there is smoke coming out of a system. Only an operation that has this effect can be considered an attack under IHL. Right, so this follows the interpretation of the notion of attack as it is understood with regards to kinetic, traditional warfare. And so if you follow this narrower approach, then the answer, would disabling a banking network, right, constitute an attack? Then you have to answer that in the negative, because there is no physical damage, right? So the computers at the bank might not be operating anymore, but there is no smoke coming out of anywhere, to simplify things. So on the narrower view, this would not constitute an attack. Now, on the broader view, on the other side, right, which is a view which is taken by a growing number of states, and it is also the view of the ICRC, cyber operations that disable a computer or a computer system constitute an attack, right? So it's enough that they disable a system, And it is irrespective whether the object was disabled through destruction or whether it was disabled in any other way. So, for example, through a cyber operation that renders it dysfunctional. And there are a number of arguments that one can advance, but let me just, in favor of this view, let me just highlight one that I consider the most convincing, and that's the object and purpose argument. In other words, the teleological argument, looking at the purpose of the law. So the purpose of IHL in this part is to protect the civilians and civilian objects, right? And if we have two interpretations in which one would permit significant negative effect on the civilian population that the belligerents would be able to do just because they change the way they operate from kinetic to cyber, then that interpretation is probably not the more convincing one. So we should go with the interpretation that is more in line with the object and purpose of IHL. And that is, in my view, also in the view of the ICRC, the broader view that you see in front of yourselves. And so let's finish on with the second of these key questions, and that's how we interpret the notion of objects. So again, we see on this slide something that's from the physical world. Normally in the physical world, we don't have a problem. If we see that something is a school, then unless it is being used for military purposes, we know that that's a civilian object which would be protected. If we see that something is a military revetment, as on this satellite image, then we would imagine that it is a military objective that's not protected by IHL. But it turns out that in cyberspace, the question of data as an object is a controversial one. And so let's again highlight the two possible views. One is that data, such as what I mentioned before, social security data, would not constitute an object. And so it's a number of experts and also some states that take this view, that data does not qualify as an object. And the reason why, the main reason being advanced is that objects are things that are visible and tangible. So like the chair that you're sitting on, you can touch it, you can see it in front of yourselves. That's what object was meant to cover. On the other hand, there is the view that data is an object. And so that perspective takes what we call evolutive interpretation, that perhaps the notion of object 40 years ago, when these rules were being drafted, when the additional protocol was being drafted, might have had a certain meaning. But if you ask people today, you know, if I delete all of the content of your Instagram account, do you consider it like something of value has disappeared, has been destroyed? Perhaps people would give a different answer. And so what we understand as an object also evolves over time. Now, whether you take one or the other has very real repercussions, because on the narrower view, the data does not qualify as an object. Social security data, like what I mentioned in the example, would not be protected, right? Would not be covered by the targeting rules, and so their destruction would not have to be justified by reference to the test of a military objective. On the other hand, if such data is protected in the same way as it would be if it was in paper files, right? Because there is no question that if the civilian data was contained in paper files, it would be protected by IHL. So if we accept that the change of paper to data should not take away the protection, then we should take the broader view that data can qualify as an object, at least under certain circumstances, and thus it would be protected by IHL. So the devil, as always, on all of these things is in the details. I try to present them as much as possible, you know, outlining the two various views on both of these key questions. Hopefully that will help you analyze and understand other questions of how IHL applies to cyber operations. And I look forward to discussing other questions or these ones in more details during the presentation, during the Q&A. Thank you.
Thank you, Kubo. Just to conclude also on the more on an official remark is that Estonia would always be a strong supporter of the ICRC and the work it does. And we're very grateful for the work that it has already been doing in this field also. So thank you. But if this was a regular conference, we would also have a chance to go for a breakout session during the coffee break in a physical world. But unfortunately, this is not the case. But I will have just a quick fire session of one question to all of you. And I'll try to get into all the questions that have been proposed in the workshop platform, where we see that there is a lot of now understanding or not non-understanding in the sense of how the physical and the kinetic and the data and the non-physical actually interact. But in the sense, we understand that we are dealing with a global issue here. And in many cases, it seems that we interpret the same things or the same scenarios a little bit differently. So my question is to all of you in a, let's say, 1 minute answer that I expect from you, because you're lawyers, you're supposed to do that. What should we all agree upon as the minimum standard baseline of, let's say, legally definitive norms? And how do we achieve it? Because at the moment, we see that we are still disagreeing or hassling over different interpretations. Let's do in reverse order. So, Kubo, you're already warm, so you start.
Yeah, you don't need to put me on the spot, right, Erkki? Okay, so I think let me just build on the presentation that I have just given. I think from the perspective of international humanitarian law, the very, very minimum that I believe all states should be able to agree on is that IHL applies to cyber operations. It applies in all domains, and so it doesn't matter if you classify cyberspace as a domain or not. It applies to all means and methods of warfare, so it should apply to the new ones as well. And I think the sooner we all realize that that does not legitimate any type of behavior, but it serves as a constraint, the sooner we can move on to the more interesting and the more challenging questions about how specifically it applies. And so when we move on to that stage, I think again, you're asking for the minimum agreement. So I think at the minimum, we should encourage states to publish their views on these issues so that we can see, I gave 2 examples. What is an attack? What is an object? We can debate this, and the 2 camps, if there are 2 camps, sometimes it's a little bit more nuanced, they have reasonable views, but it's good to see how states break down on these issues and also on questions outside of IHL, because in knowing which views states take, we can see where the gaps are. And so from the perspective of IHL, we can specifically see where the protective gaps are, right? So if all of the states took the view that ICRC does not hold, that attack is limited to causing physical damage, but if all states took that, we should, of course, respect that, because that would be the prevailing or the general interpretation of international law. But then we would know that this poses a great gap, because operations like the one I described against the banking sector would not be protected by IHL. So then there would be a need to develop international humanitarian law, perhaps by agreeing new rules, perhaps by other ways, and thus plugging this protective gap that we would identify. So 2 steps. Number 1, I think it's very important that we reaffirm that IHL applies in cyberspace. And number 2, that we very quickly identify where the protective gaps lie and then agree on ways of addressing them.
There's much of that I agree with, but Catherine, what's your take?
So at a minimum, I would say that we would want all states, all members of the UN to agree that the UN Charter and all of its provision applies to cyber. So that is the agreement that I would say at a minimum we want to have. And that, we have some of that. Article 2.4 use of force seems to be general agreement, but we still don't have agreement on Article 51. Right? I would want that agreement. Then, as a requirement, I would say all members that are participating in the UN processes with respect to cyber, and I would extend it, all UN members should submit their positions on the following legal issues related to cyber. And I would literally give them, if I was a Secretary General, I would just say, okay, I want everyone, here's your homework assignment. Every member in the UN, please submit a 5 to 10 page paper identifying your legal positions with respect to the following principles: due diligence, non-intervention, use of force and armed attack, countermeasures, also collective countermeasures, and plea of necessity. I would say these are the most important right now. And I would say take 3 to 5 pages, send it into the UN electronically, and that goes beyond just the GG members. I would say the whole group of the OEWG.
Thank you. Anna Maria, you have the last word, the final stance.
Yes, thank you for the great question, and I agree to most of what the my co-panelists have already iterated. If you ask me to choose one kind of last stance or the step or the position that we shouldn't step back from, I think it is the broad application of international law to state behavior in cyberspace. I really hope that the open-ended working group finds an opportunity to reiterate that position in a way that would be approved by all of the members taking part in that format. If I could wish a little further, but I don't know how realistic that is given the challenges that were outlined before, I would hope that the UNGG report of 2015 would be as the starting point of further discussions, notably not only the iteration and the explanations therein regarding international law, but also the norms, the 11 norms mentioned before. So, in short, let's not start discussing whether international law applies. Let's agree that it does, and let's be constructive in our further discussions.
Well, thank you all. It has been a very eye-opening and a very nuanced and a detailed panel. I would regard it as a success insofar that nobody got locked into the cat face Zoom filter. So that has been achieved. Thank you all panelists. I had a very good chat with you today. I hope to see you soon in the future as well. And I will now give over to Heli the floor.
Thank you, Erkki, for this chairing of a challenging legal panel. And I think out of all legal panels, this was one of the most interesting what I have seen in my cyber career so far. And we just run over for something like 12, 15 minutes. I think this is also within the limits when we talk about the legal panel. So thank you, all the lawyers. And let us now progress with the next panel. And this is dedicated to cyber capacity building. We are going to discuss the expectations, requirements, and challenges related to capacity building. And we are very happy to have the remarkable capacity building experts with us today, that all of them have a wealth of experience with capacity building issues from global, European, and other perspectives. So I am pleased to welcome first Naja Parpalju as the chair of this discussion. Naja is currently a director of Cyber Lab International, based in Geneva and Athens. She has lots of experience in capacity building policy and capacity building programming and public-private partnership. And she has been working before at the World Economic Forum as the head of the public policy and government affairs. And we have been working together in the European Commission, where she was the program officer and the major leader on the capacity building field since 2013 to 2018. So she has been instrumental in kicking off some of the EU's still running very successful cyber capacity building projects. Then we have Chris Painter with us, who we can call as the first cyber diplomat in history. And as you know, Chris was the first US special envoy appointed as a cyber coordinator at the State Department in 2011. And he was at that post until 2017. And of course, Chris has also 30 years of experience in cyber affairs, as he was serving as the US federal prosecutor, trying high-profile cybercrime cases, also working for FBI, White House, and Department of Justice. And now we are welcoming Chris here at our panel in the function of the president of the Global Forum of Cyber Expertise Foundation. Welcome, Chris. And then, of course, There is the panelist, Alexandra Seeger, who I think does not need introduction in our cyber circles and global cyber community, because if somebody has cyber friends everywhere in the world, this is Alexander. And he has been with the Council of Europe since 1999, and is serving now as the head of division for cybercrime. And he's also the executive secretary of the Cybercrime Convention Committee, as well as the head of Cybercrime Program Office of the Council of Europe. Alexander is known as a major architect and implementer of many successful capacity building programs that are addressing cybercrime globally. And of course, he's going to talk to you about those programs. And then, last but not least, I have my dear friend, fellow Estonian here, Ms. Liina Areng, who has a wide range of experience in enhancing cyber resilience across regions. She recently started as a regional program lead at the EU CyberNet, which is a network of cyber experts and practical learning platform. She has been working in the Estonian Information System Authority, in the Ministry of Defense, and also at the NATO Center here. And prior to this post, Liina was a lead advisor in EU's Cyber for Dev program that was doing capacity building in Africa, Caribbean, and Asia. So with all these very distinguished experts on our panel, I am sure that we will learn major and key issues and key challenges in cyber capacity building from you in the next roughly an hour. Thank you. The floor is yours, Naya.
Thank you for a very kind introduction for all of us. Obviously, it is a great pleasure to be connecting with you, even virtually, at this second Tallinn School of Diplomacy, of Cyber Diplomacy. I want to start off by setting the scene and try to do it in a rather brief manner, also to give more time for interaction with the other panelists on why we are even having capacity building in a course of cyber diplomacy. And I would just say, just as a reminder for anyone out there, please don't forget to put your questions at the workshop up, and we'll try to pick them up after this first introduction point. And since it is a school, it means, as you've seen in the previous panels, we'll have about 10 to 15 minute introduction set points from all the panelists, and then we'll move to the questions. So why, what is cyber capacity building to begin with, and why we're having a session around it in a diplomacy school? There is no definition of it, or there is no single definition, rather, as the concept of cyber capacity building has evolved as a key part of the international cyber policy, most notably since 2010, where it was at a more nascent and ad hoc stage, where we started seeing also countries developing their own international cyber policies. And that's why I think we have to go back to where the term comes from, and capacity building or capacity development does come from the international development community, where we are saying a definition would be the processes where people, organizations, and society as a whole are strengthening, creating, and adapting the capacity over time. So it's important to think that when we're talking about cyber capacity building, it is an umbrella concept that entails a lot of things, and it is actually means a lot of things to different people in the communities, and that's actually part of its charm and part of its challenge. For the purposes of this discussion, where we are going to consider it as those type of activities that develop capacities and capabilities to mitigate the risks to a safe, secure, open digital environment and its use. But why is it of strategic importance? Why are we discussing this? It is like the common thread, and I think, if we're linking to what I said about an umbrella concept, the importance of it lies that it can be an enabler for everything that we identify as a building block on cyber policy or cyber diplomacy. So on the one hand, we can see it as that element that supports the cyber resilience building across countries or organizations that contributes to an improved global digital ecosystem, and that should be a win-win for everyone. On the other hand, it also helps to foster strategic alliances amongst countries or organizations that aim to promote a common vision on cyberspace and its governance when we are talking about open, free, and secure cyberspace. And then we're looking at the maybe more operational dimensions. It encourages the creation of formal and informal cooperation frameworks between countries, regions, organizations. And finally, the more developmental dimension is its link with the 2030 Agenda for Sustainable Development. And this might not come natural to those engaged in capacity building more of in a technical dimension, but it is important to not forget even a bigger picture on how capacity building activities support the implementation, development commitments and ambitions. The final ones that I mentioned on how its meaning has some implications links to the fact that capacity building activities in cyberspace transpire from different or sometimes competing motives and ideas in different communities. And I'm meaning more if we're looking at more technical operational versus policy or more development and the like. So what we need to do, and it's part of the discussion today, is to understand those and also be able to use them and leverage them. The important piece is to understand it as a silver thread in the context of a broader cyber policy landscape. So when we're talking about cyber resilience, how capacity building can play a role in that. When we're talking about addressing cybercrime, the same. Diplomacy and international security, we've heard the previous panel and also yesterday, but as well as in not so much the narrow cyber field, but more broadly when we're talking about access and connectivity, digital economy, or even cyber defense. For this discussion, of course, we'll focus much more on the civilian dimensions, and that's why also the more traditional capacity building models have sprung out of the international cooperation field, even if they're not necessarily using those principles. But we've seen very much the model of donor-partner partner country model or donor partner organization model, with implementing actors primarily from either international or regional organizations or NGOs, quite less so private sector as an implementer of capacity building activities financed by governments or multilateral organizations. And however, this is not limited, it should not be limited to only the government-to-government relations, but we really need to see it in the broader context. There has been a lot of activities, even before the term was used to denote this field. We've seen peer-to-peer exchanges that have been happening for decades, even also as well as private sector efforts on skills development and the like. The foundational building blocks of cyber capacity building to date have been more focused on the capabilities of nation states and their enabling environments and organizational capabilities. So we have seen much more focus on development of national strategies, the development or strengthening of capability for incident management with the setup and maturity of certs, as well as hygiene and awareness type of activities. And of course, maybe the first has been more focused on cybercrime, given that in its own right, the cybercrime ecosystem, let's say, has been much more mature in comparison to the more cyber ecosystem. However, there is a growing number of initiatives and activities, including on cyber diplomacy. This is one example that aim to increase the awareness around cybersecurity norms, the application of international law in cyberspace. So we've seen the growing interdependence of cyber issues with also more adjacent issues in terms of emerging technology, digital access, is also affecting the scope of cyber capacity building. So we cannot just say it is just this or that, but we really need to see it in the broader context. And for that, a more holistic design, potentially thinking of more of an ecosystem approach, might be also a way to overcome more of a siloed activities. As this scope has been broadening, this means also the stakeholders have been broadening. So on the one hand, we have more of a traditional organizations engaging in this. The EU has been one of the first to actually link cyber capacity building with its development aid and development funds. There is many activities that other donors such as the US, Australia, Japan, Korea, several EU member states as well, like the Netherlands, have been doing and financing across these fields. And what we see is we are an increasing number of actors acting, not only having more of the donor hat, but we're looking also in models of triangular cooperation, where we have also countries from the global south really sharing their expertise and being also brokers in a more of regional approach. One important point to let's say wrap up this first scene setter is to think of the role of regional organizations, where they have played in many cases, such as the Organization of American States, the ASEAN, as well as the African Union and several of the African regional economic communities, the Organization for Security and Cooperation in Europe, have actually been quite substantive partners in putting these capacity building activities in place, and also creating this mini community of like-minded partners that really want to engage in enhancing capabilities of states, and how that trickles down at the national, regional, local, and also individual level. The community has reshaped a lot over the last decade. As I mentioned, we can see the term being more broad, starting to be used around 2020. Since 2015, with the creation of the Global Forum on Cyber Expertise that Chris is going to talk to us about in a minute, we've seen also how it has linked up and created much of a broader network of policymakers and program managers working in this space. And in most recent the last couple of years, we also see it very prominently coming up in all the international fora and the discussions that are taking place, not least at the UNGG and the Open-Ended Working Group, but also at the Internet Governance Forum and many others. And the interesting part about capacity building, it is a consensus area of cyber policy globally. The tweak is maybe that it is a consensus because we haven't really gotten down to agree on what is the vision on what we need to achieve. And I think that is more of a kind of a quo vadis question, or where are we going? What are the lessons and challenges that we've been facing. Are we doing enough as an international community to actually create that, elevate capacity globally and reach that hopefully 100% capacity if that is even possible? And what are the externalities affecting it? Because certainly we are in a highly tense geopolitical environment, and we cannot be naive and think that also the capacity building ecosystem is not affected by that. I would really wrap up here and suggest that one of the key points that we've seen in this as a trend is more of an increased number of stakeholders that they are really eager to engage, not least from the private sector, but obviously also not-for-profit organizations, and not necessarily yet with a more systematic professionalization. There is a lot of improvement to be done for learning from each other and creating those feedback loops from other communities that have been doing this for much longer. And also, as the complexity of cyber issues is becoming more and more pronounced, that means that also capacity building, complexity, and investment is going to continue. And what are the key dimensions that we need to consider to actually have more sustainable and impactful activities around that? I would say I would move to with this more Quo Vadis question to Chris Painter in his capacity as the president of the foundation board of the Global Forum on Cyber Expertise that I mentioned in 2015 was created as a response to this gap of knowledge and expertise. Maybe Chris, get us through the GFC, I would say, evolution and journey, and maybe let's check in on how we are doing in terms of lessons, challenges, and actually sustainability of efforts to date. Over to you.
Great, and it's great to be here with all of you, and also I want to especially thank Heli for putting this on, and Estonia for putting this on. This, as was said, is actually a form of capacity building, policy capacity building for diplomats that I think is critically important. And I'd also say, with respect to capacity building writ large, I view that, and I think all of us really view that, as foundational to all the other things we're trying to do in cyberspace, whether it is aspects of international law, norms and stability, better awareness, better ability to deal with things like cybercrime or cybersecurity issues and to respond to them. All of that really is undergirded by having capacity building so countries can deal with these issues, particularly as more and more countries are recognizing the importance. And indeed, when my office was created at the State Department back in 2011, my old office, one of our pillars was capacity building, and we very quickly started to do capacity building programs in sub-Saharan Africa, and certainly have worked with Alexander and others for some time on these issues. So I'm going to use a slide deck and see if this works. Nope, there it goes. Sorry. All right. So I want to talk now about the GFC. As it was mentioned, it was founded about 5 years ago on the premise that there was a lot of different capacity building efforts out there, but they really weren't very organized, coordinated. We used to joke when I was both at the Department of Justice and State that sometimes the same 2 people in the country were trained by 6 different people from all over the world. And that's really not using these scarce resources in a way that is helpful or effective. So the GFC's vision was an overall vision to create, as we all do, an open, peaceful, secure, and digital world. And to do that by strengthening international collaboration on cyber capacity building and expertise. And we had 3, and we still do have 3 strategic objectives. One is to avoid duplication of efforts, as I just mentioned, and that means coordination. 2 is share knowledge and expertise, so that is knowledge sharing, which we need to do. and 3, to match needs and offers for support. So this is matchmaking to put the people who are the donors in the space, the people who are the implementers in the space, together with the people who need the help, and do that in an organized way. What's unique, I think, about the Global Forum on Cyber Expertise is its multi-stakeholder nature. It is not just states, although it was created at the Global Conference on Cyberspace in 2015. It includes over 120 members and partners. 57 of those are states, and that's growing. Numerous private sector, civil society, and academia members. And that really, I think, helps us have a richer debate about these issues and do coordination more effectively. Our mission was first set out in something called the Delhi Communique, and really that broke our efforts into 5 areas, and there's sub areas for these. One is cybersecurity policy and strategy, which includes diplomacy, norms, and international law aspects, but also involves national strategies. 2 is cybercrime and cybercrime policy issues. 3 is cybersecurity standards. 4 is cyber incident management and critical infrastructure protection. That includes building CERTs, or computer emergency response teams, around the world. And the final one is cybersecurity culture and skills. To implement this, the GFC has several tools. 1, what's called the Sybil portal. 2, the Clearinghouse, and 3, our research agenda. Now, obviously, this is very small print, so these slides will be available afterwards. But really, the Sybil portal, what I want to make clear about this is this was created now about a year ago, and is essentially a portal that's open to everyone, where we partner with many different organizations that are listed here, including the Diplo Foundation, FIRST, ASPI, and others. And we try to aggregate in this portal a number of information sources for governments, for industry, for civil society, for implementing agencies, for donors. That includes things like best practices. It includes products that were done by the GFC. It includes products that were done in other areas. And a central locus and links to other locuses of documents and best practices that can be helpful to everyone. There really hasn't been that before. So this serves as really an asset for the entire community. The second area, the second tool, is the Clearinghouse, and this is the matchmaker function, which I think is critically important, and really I think the motivating reason that the GFC was set up in the first place. And the idea here is to match, as I said, the people who really need help with the people who can provide that help, and to do that in a more coordinated way. And this is done in a way that puts together the donors, the implementers, and the recipients, and also tracks the progress. So in the preparatory phase of the Clearinghouse, the GFC Secretariat identifies a request for support from a member or even a non-member country. We look at it, we make sure it's clarified, we make sure they know what they actually want, we make sure that there's the necessary buy-in from their government, other things that may be necessary. The key part is the coordination phase, where we bring together, we kind of create what we call the friends of whatever country. Say Sierra Leone, because that's been a very good example that we've been taking forward. And this is a coalition where we can do matchmaking among a number of different members and partners of the GFC, where we can look at what's offered and match it to what they need. And that's resources, that's implementation, that's other things along that line, which is critically important to get the help they need. And then finally, the implementation phase, where we take that plan that we created in phase 2, and we start executing it. We make sure that the implementers and the donors are actually implementing the plan, that it's being done in the country, that we track its progress, most importantly. And we just don't walk away. One of the big problems, I think, in capacity building in the past has often been, people do a training, some sort of training thing, and then they leave and there's no follow-up. And so all the progress that's been done has been lost, or people move on. We need to make sure that we're having the maximum impact, again, because our resources are relatively limited. The third tool that I want to discuss is the research agenda. And this is relatively new as well, less than a year old. But this is a global research agenda where a lot of these working groups I talked about, the ones on cybercrime and strategy and incident response, etc., we're looking, one of their main things was to map what was out there in the world and see where there were gaps. And now we're using this research agenda to figure out where the gaps are in research that needs to be done. set the agenda for that research, and then, actually encourage and, if possible, fund that research so that it's done in the community and can add back into things like the civil portal, or also help countries in their day-to-day progress. Now, going forward, there's a number of things that we want to do. I think we've had tremendous growth over the last 5 years in terms of participants, in terms of work we've done. We participated in discussions in the open-ended working group and others. We want to be the platform that's helping with all these efforts now that these efforts, I think, are getting the recognition they need. We still need to go further. We still need to get more recognition in the global development agenda. I think cyber is too often siloed off. But our key things are, one, strengthening the GFC brand, which is make sure that people know about us. We can't actually perform the function we're designed to do if the countries who need help, or donors or implementers, don't know about us. And so we have lots of great members. We want to expand that. We want to also, and this is our second objective, make the GFC more inclusive. And that includes more countries, more implementers, more industry participants, more civil society and academia. And we're making good progress on that as well. We want to enhance our collaboration in the GFC community. So look at all the tools we have, the working groups we have. People volunteer their time and have been very helpful in that, but make sure that we get the right people in and that they're actually working and helping, and that we have the collaborative environment. We want to increase the GFC's regional focus. Our last annual meeting before COVID was in Africa, and so we have a project now in Africa. We're doing some things in the South Pacific, where we're looking at regional hubs. These are all important steps so that we can be even more of a global organization than we are. And then, I think one of the things I think we see throughout this space is, I think we're unique in terms of what we do in the capacity building realm, but there are lots of other organizations that have pieces of this. And other platforms, and I think connecting to those other platforms are important, whether they be the Cyber Peace Institute, or a number of other, the Global Cyber Alliance. There are many different things that are out there which are doing issues which are helpful in this area, and it doesn't make sense for all of us to do it in stovepipe. So we're trying to expressly connect and bring those groups together. And also, I think, raise the political awareness of this issue so it's not seen as this boutique issue. And then finally, it's really the rising ship lifts all boats. We're trying to enlarge the pool of international resources, which means that this is not seen just as this simple issue of that people tuck away as oil, cyber capacity building, cybersecurity capacity building is this little thing. It really is, again, foundational to development goals for countries. And so if we start thinking about it that way, that opens up more resources, more political awareness, and we very much need to do that. So with that, I will conclude. I will say, point people to, it's at the bottom of the slide here, both the contact, if you're interested in more information about the GFC, there's a contact at thegfc.org, and also the GFC's website, which is www.thegfc.org for more information. But I encourage you to be aware of this. If you're in a foreign ministry, this is something I think that should be part and parcel of your program, and we stand ready to help you. So thank you.
Thank you, Chris. This was quite comprehensive and crisp and short. So I'll come back to you during the Q&A also to connect some of the dots with what we'll discuss also further today. With Alexander, I think you might be certainly formally the first cyber capacity building project that I'm aware of in 2006 with the Council of Europe, but I imagine informally long before that. Please, the floor is yours to give us some perspective on the efforts that the Council of Europe has been spearheading in the fight against cybercrime and increasing capacities globally to this end. I believe we cannot hear you, Alexander.
Can you hear me now?
We hear you now. Yes, perfect. Thank you.
Okay, it's a weird system here. Okay, it's great to be on the panel with so many good friends from for many years actually, And Naya, believe it or not, I had a life before the Council of Europe. At some point, 30 years ago, I worked at the United Nations, and in the run-up to the UN Crime Congress in Cuba, there was the question of whether the United Nations should do a cybercrime treaty, or computer crime treaty, as it was called at the time. In 1990, in Havana, there was no agreement on a new treaty, actually, because there was no old treaty, no agreement on a treaty on the matter, but there was broad agreement on technical assistance, or as today, we would call that capacity building. So there's a long story to that, but then after Cuba, nothing happened for about 15 years, and I got involved in around 2004, 2005, as a lone voice for quite a while, but I must say over the last 10 years, capacity building on cybercrime has taken off, and I think it is a success story. I put on this first slide, in a way, takeaways, the points to retain. So whatever else I'm going to say after this, you can ignore, but maybe you should take this with you. The first thing is that 15 plus years of experience have shown that capacity building on cybercrime works, and it makes an impact, and it meets needs of practitioners. And speaking about the Council of Europe perspective, the mechanism of the Budapest Convention on Cybercrime provides for a criminal justice response that is consistent with human rights and rule of law requirements. This is the second point I would like you to retain. Related point is that a new second additional protocol that we are currently negotiating on enhanced cooperation and disclosure of electronic evidence will provide for added operational policy benefits. And the last point, to retain, any international initiative on cybercrime should be based on consensus to permit more cooperation and avoid further polarization, meet human rights and rule of law requirements to maintain a free and open internet, meet the needs of criminal justice practitioners, and be consistent with existing standards. So these points seem a bit isolated now and not make much sense to you, but let me now explain what is behind this point for the next 7-8 minutes. The rationale of capacity building is not to protect computers because we like them and we like to play with them. There is a broader rationale to it. Capacity building on cybercrime and electronic evidence contributes to the rule of law in cyberspace. It's of course connected to cybersecurity issues and enhancing security, confidence and trust in ICT. And all of this has to contribute to some overriding objectives of international security, but also human rights, democracy and the rule of law. And as Naya already mentioned, sustainable development goals. So this is how you can place it in a rationale and how it's possibly linked. This is one way of looking at it. And we have been following this rationale. I can tell you over 15 years, this has worked quite well. Now, capacity building is not somebody going somewhere and doing some training and then moving away. Chris also referred to it. There's been a lot of this ad hoc training of somebody coming in and leaving, and that's it. We look at capacity building as a support to a process of change. If a country is in a situation A, and wants to get to a situation B, this process is to be supported. If we take an example that we have all the time, the country has no legislation on cybercrime, we help them develop legislation in line with the Budapest Convention. Again, from our perspective, others may use a different perspective. But if a country does not know what they want, there's nothing to support, then we shouldn't go in. Right? Very important rationale. Capacity building is there to support something. And the clearer a government can determine what it wants to do, what the objectives are, the clearer you can have a process of change, and the clearer is also your capacity building interventions. This is very important for us. The way we do it at Council of Europe specific again is we have the Budapest Convention is a wonderful, nice little booklet which is growing, but it is a mechanism. It's more than just a treaty. It has the convention, yes, and related standards. There's already a first protocol on xenophobia racism, but there is also a follow-up mechanism, the Cybercrime Convention Committee, which is currently negotiating a new protocol. And the third part of it is capacity building. All of this is interrelated. I'm sitting right now in Bucharest, in Romania, in the Cybercrime Program Office of the Council of Europe, from where we do capacity building worldwide. And we'll soon have our 7th anniversary of the office here. And I think by that time, we will have done about 1,400 activities over 7 years in about 130, 140 different countries. The Budapest Convention will have its 20th anniversary this year in November. It's about providing for specific offenses against and by means of computers, procedural powers to secure electronic evidence in relation to any crime, and international cooperation on cybercrime and electronic evidence. There's some complements to it, guidance notes to explain that this device here, this is also a computer system in the sense of the Budapest Convention. That was guidance note number 1. There are lots of other guidance notes to explain how you use the Budapest Convention for spam, botnets, terrorism, and so on. And as I said, there's a first protocol of 2003 on xenophobia racism via computer systems, and a new protocol is currently being developed. Important, we have 65 parties and 12 states that have signed it or been invited to accede. It makes 77, and in a way, we're not the G77, but the cybercrime 77 group of countries. The current protocol will have operational and policy value. It's very important. It provides for direct cooperation between the service providers in other parties. It's very important, in particular for countries in the global south, but any country. You would like to get subscriber information from a service provider that is not in your territory, but is offering a service in your territory, to find out who did it, who is the offender, who is behind a social media account, behind an internet protocol address. This will be the first international agreement providing a legal basis for such cooperation. And there are other tools in it, including for instant cooperation in emergency situations, and so forth. So a number of tools this protocol will provide that provide value for practitioners. But there's also a policy value, namely that the Convention on Cybercrime, the Budapest Convention, will remain relevant and effective, and that it underlines that the respect for a free internet with limited restrictions in case of criminal misuse, very specific restrictions with safeguards and powers with safeguards. All of this designed to maintain a free and open internet while still going after offenders in an effective way. Very important, the rule of law and human rights safeguards in this protocol. The reach of the convention and the reach of capacity building, as I said, we have been working with more than 150 countries. Actually, we did a count recently and we came up with 165 countries that we have been working with. We have, as I mentioned, 77 states that are parties or have been invited to accede or have signed it. But there are lots of other countries, in addition to those 77, that do have domestic legislation in line with the Budapest Convention, among others, or in particular as a result of our capacity building activities. I think by now we have about 110, 112 countries that have the substantive criminal law provisions of the Budapest Convention reflected in their domestic criminal legislation. We have here a link to the Octopus community on our website, which has lots of country wikis, legal profiles and other things in it, where you can get details to see what country has what in terms of legislation, in terms of also an overview of cybercrime policies. In terms of capacity building, we set up this office here in Bucharest in April 2014 to have our own capacity for more capacity building activities. We have here about 35, 36 staff in the office. We work with lots of experts from around the globe in addition to that. And we have currently a number of programs running with a combined volume of about almost 40 million euros. Some are for certain regions in Europe or elsewhere, or we have also programs that are global, like the Global Action on Cybercrime Extended, or GLACY Plus, where we can work anywhere in the world, funded by the co-funded by the European Union. We have another project, the Octopus project, which had some precursors, but there's a new Octopus project that started last month, where we have also contributions from the United States, from Canada, and from other countries that are funding that. So we have a good amount of resources available to help countries. In conclusion, and again, this is not now some abstract points to make. We are talking here about 15 years of experience with lots of activities through this office alone here in Bucharest, more than 1,000 so far. Capacity building works, responds to needs, and makes an impact. We can measure that in terms that we see improvements in legislation with safeguards, in terms of investigations and criminal proceedings undertaken domestically or internationally, in terms of improved public-private interagency and international cooperation, and sustainable training systems that we helped establish. Capacity building facilitates multi-stakeholder cooperation, partnerships, and synergies. It has human development benefits and feeds into sustainable development goals. It helps reduce the digital divide, very important. And as Naya and Chris pointed out before, it is based on broad international agreement, and it may also help overcome political divisions that we find all over the place these days. And back to you, Naya. Thank you.
Thank you, Alexander. Also, we discussed before about linking with the development and all of the principles that you have described that you guide and the capacity, your own capacity develop to deliver capacity. These are quite interesting points to after here from Lina, but a very quick reminder to those that they are online and watching to put your questions via workshop by clicking the tab next to the agenda item, and we'll take I want to shift to Lina and maybe talk more broadly about cyber resilience. You have experience both within Estonia, but currently Cyber for Dev project all over the world, working with governments in helping their journey in developing national cybersecurity strategies, incident response capability, and the like. I would like to hear from you, Lina, your thoughts on what are the key challenges partner countries in the global south are facing? What are the lessons to impart, both from success stories, but also from potential failures, and how we are going forward in this field, more broadly, of course, on the excellent experience that you have for many years, also building on the Estonian golden standard, if I may say. Obviously, this is also an Estonian course, but it is important to mention that it is for a reason that Estonia has this global reputation, as it has really focused strategically on digital and cybersecurity as a national priority. So over to you.
Thank you very much, Naya, for this extremely kind introduction and very warm greetings from freezing Tallinn, the golden standard Estonia, to my fellow panelists. So I'll try to add a practitioner's perspective to what the previous speakers have said, as I have been working hands-on and boots on the ground, at least when that was possible in the good old times, in different EU projects. And as Naya explained in the introduction, EU has become a visible and an active player in the global capacity building arena, and what EU adds to this international capacity building, cyber capacity building community is an important element of cohesion or collective knowledge, because EU has now for over a decade tried to harmonize the maturity levels of the different EU member states, and definitely also shares a joint vision for a global, free, and inclusive and open cyberspace. What could I say to answer your question, Ion? To discuss a little bit of our experiences, challenges, victories from the ground. Maybe to say a little bit in the broad terms what the countries, what the recipient countries expect from the donors. I think they all expect change in very broad terms. And if we categorize countries by their by where they stand in terms of digital development and their cybersecurity maturity levels, then those who are just starting their journey are needing a wise and impartial helping hand. Sorry to say that, but these are the countries who are very easy target for the cyber capacity building hawks who are driven by political or business interests and try to impose some sort of models or solutions that might not work in this particular context because of the given maturity level or geopolitical or cultural setting, because the shiny grand organizational charts and operational models or technical solutions that are copied from larger and rich nations do not work everywhere. And cyber capacity building is not a copy and paste exercise. Imposing something that is not really needed and that is not theirs is a waste of time and money, and what it does also, it does harm to the overall trust towards the international capacity building donor community, and it also erodes trust within the recipient country. Because the trust in the society towards the government who accepted this assistance that ended in a rather negative manner, and trust is really essential to achieve anything tangible in digital development and cybersecurity. What do the more mature countries or partners expect from the donors is that they expect real tangible collaboration and information exchange, operational information exchange, and access to the donor community's CSIRTs, and be accepted to as equal partners to different international forums. But what they sometimes don't realize is that when they are included in these forums, they are also expected to share, not only receive, but in order to be an equal partner, you also are encouraged to share. And this is also how international collaboration, or how CSIRT collaboration happens between the EU countries, is that you receive when you also share. So it is very important that we encourage the partner countries to contribute to different forums, international events, and not only to engage
engage more women to take the floor, but also to engage those so to say countries who are starting their path of digital development, because in some respects they might have even more they might be more innovative than the so-called old democracies, that equals old bureaucracies that are more reluctant to change than the so-called new kids on the block. What else can we do to help both more mature and less mature countries is that we should build the bridges of collaboration, real practical collaboration and information exchange, and facilitate collaboration between the partner countries and the donor countries, and create some sort of longer-term mentoring schemes, motivate the CSIRTs in the donor community to mentor and help the less mature CSIRTs, and if possible encourage some sort of professional internships. Also study trips are very helpful, as I've understood, to bring partners to meet with their peers in Europe, US, Japan, New Zealand, wherever, to see how the teams operate elsewhere, to collect new ideas to bring home and transform their organizations. What we have also discovered is although acknowledging that all countries are different, is a pattern that the political leadership and management levels are obsessed with looking good at international indexes and comparisons, and if such project-oriented approach would be very plausible in other respects, then if you're operating under time pressure from your management, then you lose focus and you focus on the targets but not on the process. But if you try to regulate something, impose standards or obligations or burdens to companies who, without having a good knowledge about their infrastructure or their business processes, and these companies are the critical information infrastructure operators, then this is a dead-end process. This quick approach on regulating something just to leapfrog in some international indexes is not proving to be very effective if the aim should be to build community and trust amongst your stakeholders. So what we always advise our partner countries is to resist the temptation of ticking the boxes and in the maturity indexes, because they are only helpful if you integrate that into your normal planning processes, and it shouldn't be a standalone thing, because this does not measure your true performance, but drafting some sort of law, regulation, or policy should also be a learning exercise, in a way also to engage your stakeholder community. So they need to take time to invest time in the process rather than on the overall aim to improve their status in some international index. And what is also quite obvious, what partner countries don't accept or expect from donors, and here I'm quoting a good friend and colleague, is that when a team of donors parachute in, they overwhelm the partner country with PowerPoints and draft a few reports and then disappear without little or no follow-up. Then this is definitely a recipe of failure and shows international aid in a negative light. So building capacity should be about contributing to building local communities and encouraging bottom-up approaches and enthusiasm for change and empowering local organizations. And a successful project should take time to focus on the broader goal. So these can be the overall development goals or a digital agenda, and transform this goal into concrete actions or concrete targets. And this is, of course, extremely difficult to do because it involves engaging a lot of local stakeholders, their involvement and their contribution, and usually international implementers or projects don't have that much time to invest so much attention and energy into digging deep into the overall socioeconomic and development agenda of a concrete nature. And what is quite unfortunate, or has been so far, is that cybersecurity or cybersecurity capacity building and digital transformation capacity building has been, for some reason, looked as alien endeavors, and I was very happy to read the recent EU cybersecurity strategy that is titled "Strategy for the Digital Decade," and it speaks about secure digitalization and cybersecure digital transformation. So it brings together these two very important elements, and this should be the broad goal of cybersecurity capacity building or cyber capacity building to also include digital transformation. So to summarize, capacity building shouldn't be a academic preaching exercise, but rather a practical exercise involving local knowledge and also a collective exercise that involves donors and implementers, or donors, implementers, and local partners. Because the aim should be to make local people believe in it, to see the benefits for their organization and for their community, and also make the politicians to believe in it. And in this way, you can deliver change because you have a purpose and purpose to deliver common good step by step. And it shouldn't be about spending more, but rather spending wisely. And collaboration between donors is crucial to make more impact. And using such coordination mechanism or matchmakers like the GFC is very, very important in this process to bring donors and recipients together to help to understand better the needs of the recipients that seek assistance and organize the assistance in a way that avoids competition and also might risk to exhaust the absorption capacity of the recipient state or recipient country, because global cyber capacity building has become a really crowded space. And some recipient countries are overwhelmed by different projects and donors who drive in and out, or rather zoom in and out, and this definitely is not assisting the country to achieve its primary goals. So, because of the broad goals are remote and complex. It is difficult to fully map and synthesize these goals into sensible actions, but this is what we need to do. We need to find somebody, GFC or some other body that would, in close collaboration with the recipient country, define this broad goal. And then divide this task into concrete deliverable actions and divide these actions among the different donors and implementers who have the funds and necessary expertise available. So it is, of course, complex but very, very necessary task. So I guess with that I will end my first intervention, and happy to join you at the Q&A session. Thank you.
Thank you, Lina. That was quite comprehensive and reflective, I would say. As we started off late, we are given the 10 extra minutes that were taken from us at the beginning. So I want to capture a couple of the key points and then move on to a couple of questions we have received. In a way, what I hear from all of you is also that capacity building in cyberspace, as in any space, is a marathon. We do see that, you know, we have a plethora of actors that certainly necessitate a coordination, even if there's different mandates or ambitions, especially as the available expertise, but also the resources are also limited. So that also shifts us to how can we maybe think out of the box, and I'm mentioning this for those following this, to think also of other type of models. Chris, you mentioned the need to elevate cyber as a key point and of an enabler in the development agenda, and especially as we are seeing also increased investments in digital transformation that Lina mentioned as well. Like, that requires also mainstreaming cybersecurity. Otherwise, we'll be at the risk of, you know, expanding the attack surface, but not really supporting with the security pieces. And then the political awareness that is important, I think, across all of you, either from an ownership perspective or from a perspective of understanding it as a point of all the other areas of policy, that capacity building is an intrinsic part of those. Alexander, you mentioned that capacity building works better where governments have determined their objectives and they are actually having a plan to go through a process of change. And that links to, Lina, also your point about absorption capacity, and maybe some of the models that some donors or implementers have good intentions but not necessarily translate into impact when we are having the points of experts flying in and out, or exhausting partners in assessments but without moving to concrete action. So with all these points, I would say two of the interesting questions that we have received, and they're very much more on the political or policy side, and it's open to all of you. How would a state seeking capacity building know who to trust if they are quite nascent in the ICT capabilities? Realistically, which organizations or countries can be relied upon to build up the state's cyber capacity responsibly, and if possible, without ulterior motives? It links to quite a few of the points that, Lina, you've mentioned, but I think importantly, the geopolitical dimension and the points that also, Alexander, you've said about it's much more impactful if we are linking it to international standards and international agreements. I leave it, I would start with anyone who wants to volunteer, and we take it from there. Chris.
So maybe I'll start and just say, look, that's a very good question, and I think that one of the things, I wanted to foot stomp a couple of issues. One, I have heard from countries, including when we did something for the Pacific Islands, that they said many countries are coming and offering them help on how, for instance, to build a cert, and they already knew that because they already had that advice 6 different times. So how do we make sure that we're actually meeting the needs of the folks who need the help? And so that's why when I talked about the scoping aspect of the GFC, that once a request comes in, or we talk to a country about a request, we really engage that country in a scoping exercise. What is it they really need? How is it going to be delivered? Who are the right parties? Bringing those together. And that really goes, I think, to this question of trying not to be, to try to be a neutral platform, to bring all these folks together in a more efficient way, to make sure that the needs of the country are met and that we have continuity after those needs are met. And I think that's critically important, because if you just do these short things, or if you don't build that trust between the donors and implementers and the recipients, you're not going to have long-term progress. You're not going to have the willingness to engage in the next level of capacity building and make sure that there is appropriate, I don't want to say monitoring, but implementation and tracking of where things are going. So that's critically important. That's what we try to do. I'd say that there are certainly barriers or issues. One of them is, quite simply resources. I mean, yes, there are a lot of implementers and donors in the space, but they're not that well organized. My organization was started by the Dutch, but we were spun off as a foundation last year. And we rely on, talking to countries, but also to foundations and others about resources. We obviously, like everyone else, need more to do this. We're a fairly small organization, so that's tough. I'd say the mainstreaming issue, which was also mentioned, I always find it hard when a country is just focused on digital development, which is important, and they don't include the cyber security aspect of that, either in their strategies or their plans or their capacity building. So I think we try to create that platform. We try to be responsive to both the recipients and to the donors, and to do that in a way that is not politically motivated, or is not based on the agendas the donors are trying to achieve versus what the recipients want. But you have to match those things together. I mean, the donors are doing this for a reason too. Part of it is out of the goodness of their own hearts. Part of it is also to help their international agendas. But those things can come together in a good way for both donors and recipients.
Very quick, 1 minute, Alexander and Lina, on this.
Lina?
Yes, actually not much to add. So I think 1 minute is quite enough. It's quite logical that different countries and implementers come in with some strings attached. Sometimes they are not even negative, but it raises suspicion amongst the recipients. So exactly what Chris mentioned, that GFC can be such neutral body that facilitates the incoming requests and try to sort of neutrally or equally distribute that amongst the donor community who have the expertise and motivation to assist. And it's also very important to have some sort of follow-up mechanism in order to share the success stories amongst the recipient community as well, to show that not every assistance comes with a negative package that might not be so or might be self-serving and not so helpful for the recipient country. So you can have a series of mechanisms that could avoid that. But yes, I think compliments to the GFC for taking up the mechanism for the matchmaking and serving as a clearinghouse and showing that international donor assistance can be actually neutral as well.
Alexander, you're saved because I have a cybercrime question. So, and we are at
but
time.
I still want to answer that.
You can combine. So let me
Okay.
share the other question and maybe combine, because it's to an extent is related. How to build capacity building in more technical topics such as cybercrime for the non-technical community, particularly important for international discussions. And I think here I would say, as we all know, there are efforts at the UN to consider negotiations over a new cybercrime treaty or a cyber anything treaty. It could be interesting to mention also the rationale on why, if this is opportune for the international community right now in terms of investment in energy and time, and if this goes on, indeed, how do we need to work to enhance capacity of those themes that are quite technical, either legislatively or operationally, for those that they are actually in the negotiations, which usually are the diplomats?
Thank you. Maybe on the previous question, on the question of trust that has been underlined by several of you. Indeed, if I were to go now and say, trust me, that would be very suspicious, or that would raise suspicions. Therefore, maybe if you want to go to Chris and GFC first, and then he sends, he clears me and clears us in a way, it may work. But seriously, we have been working with many countries over many years to build up trust. Start small, work on legislation if we are asked to, and then over time, trust may be there, or then over time, the country may ask for accession to the Budapest Convention, and then we can do also many other things, including training and so forth. Now, to come to the UN treaty question, we have to accept the fact that the General Assembly last December decided, in December 2019, adopted a resolution to go ahead with a new treaty. So I think we have to now participate in that in good faith. And if I say we, it doesn't mean the Council of Europe, but states have to should participate in good faith, and to make sure that that ends up with something that will create better cooperation and less divisions, less polarization. And that's, I think, the challenge right now. At this moment, nobody is really discussing yet seriously the substance of such a future treaty. At the moment, the discussions are underway of what will be the modalities for negotiations. The decision was made a few weeks ago that by the General Assembly again that an organizational session that was scheduled for last year was cancelled because of COVID will take place in May to discuss the modalities. And I think what would be important there is that the modalities foresee that negotiations will proceed by consensus. The resolution that paved the way for all of this was not taken by consensus, and that points already at the problem. You had 40% of UN member states voting in favor, you had about 60 states voting against that resolution, and many countries abstained. So, but still there was a relative majority, and that resolution was adopted. But again, the polarization is built in. So in order to overcome this, the modalities for negotiations will have to be or should be based on consensus. Secondly, the treaty needs to meet the needs of criminal justice practitioners to better cooperate in cybercrime matters, and therefore it should be led by experts in criminal justice matter. And experts normally in the UN context in criminal justice meet in Vienna and not in New York. In New York, the risk always is that any topic may be part of a larger bargaining, maybe just one bargaining chip in a larger market where whatever some cultural issues or minority issues are traded against cyber issues and whatnot. So it should be negotiated in Vienna by criminal justice practitioners based on consensus. And of course, it has to be, whatever comes out of it, consistent with current standards. If we say that 140 countries have based their legislation on the Budapest Convention, if you now come up with a treaty that would counter all of that, that would be a problem, not for the Council of Europe, but it would be a problem for those 140 countries that already have legislation based on current standards. So these are some of the issues there. I think it is very important also for diplomats to get more involved in this, to understand some of the issues behind. Chris Painter was himself the lead diplomat for many years in the United States. He knows very well what is behind all of this. But sometimes some innocent words and intentions, there may be a very complicated agenda behind of this, including an agenda to redesign the architecture of the internet and to legitimize the control by governments over information that people want to share and access. I leave it at that for the moment.
Thank you, Alexander. We are at time. I would really like to continue on with the questions we have received, but I'm afraid we don't want to keep the final session from its time, that we are a few minutes over. So I would like to thank you all. First of all, thank the Ministry of Foreign Affairs of Estonia for this excellent initiative, and Ambassador Heli Tilma-Klaar for their warm hosting. And thank you all for taking the time, for sharing all these updates and your knowledge. And hopefully we will also manage to get more people interested on cyber capacity building as a key area of cyber policy, and raise awareness around it. Not only because it's important, but it's also something we can use to meet both economic, political development goals that we have across the world. So again, many thanks to all, and we move on to the other session, and with apologies for the slight delay.
Thank you, capacity building experts, and thank you, Naya, Chris, Alexander, and Lina for a very interesting debate on capacity building. I think we need more of those debates, and we also would be benefiting from greater awareness of the capacity building challenges that you all also described during your panel. But let's move with our program today, and we have a last panel on building organizational and technical cyber resilience at national level. And I'm very glad to welcome here my colleagues from the Estonian Information System Agency, who are both here to tell us how the organizational and technical side of cyber resilience works. First, here you will see Siim Alatalu, who has been with the Estonian Information System Agency since 2019, and is now in charge of EU CyberNet, which is the European Union external cyber capacity building network. He will talk more about his work with EU CyberNet. About Siim, he has been working in the Ministry of Defense for a long time, and also at the NATO Cooperative Cyber Defense Center of Excellence, and he has been running a major multinational cyber exercises there at the NATO Center. Then secondly, we have here Mr. Tõnu Tammer, who is the director of the Estonian CERT, Computer Emergency Response Team of Estonia. And he has been a very strong leader in the field of technical and operational cyber field, and has made sure that the Estonian threat landscape is without threats, if I may say so, or he has cut the threats significantly with his efforts as the director of the Estonian Computer Emergency Response Team. He has the background in Ministry of the Interior and was also serving as the Counselor for Justice and Home Affairs in Brussels, and has worked at the several projects and commissions that are in charge of securing the Schengen Information System project. And both Siim and Tõnu are going to tell us how to build cyber resilience at national level. And first, Siim will start with more organizational and policy aspects of the national cyber resilience. Please, the floor is yours, Siim.
Thank you very much, Heli. It's really a pleasure to be here, and thank you for the opportunity to address the Winter School. Well, you mentioned I work as the director of EU CyberNet, and today here I'm more in a role of an expert who has been working with the Estonian development of its cyber ecosystem, and I hope to provide you with some takeaways, some lessons learned from our experience. So building organizational cyber resilience on a national level It's really been a topic close to my heart. As mentioned, I used to work for the Ministry of Defense, but in terms of cyber, I've been amongst the co-authors of the past 3 Estonian cyber security strategies. So I hope to provide you with some useful lessons to take away. I'm a historian by training, so it's always close to my heart to reflect on history, but I hope this will be also useful for the days ahead at the winter school and of course for anything that comes after. So let's start with the theory. Well, this is an academic exercise, so in terms of how you build cyber resilience, you can take the classical ends, ways, means model. So you have the objective, you establish what are the ways to achieve it, and you put together the resources. So for instance, if your national objective is to have an open and safe cyberspace, it was also discussed in the previous session, combating cybercrime is definitely one of the key areas you want to pursue, and you start by deleting gaps in legislation and by updating Act X or Y or Z. So that's in theory. A lot of details you need to take care of, you need to have a comprehensive approach, and you need to really think of everything. And well, in order to achieve any of such great plans, of course, you need to have resources. You need to have people, you need to have money, and guess what? What's the most critical thing? You also need to have time. But time, when it comes to cyber issues, it's hardly ever there. So what we see, comparing theory to practice, is that the trends in states practice, they merge the efforts on a national level. Well, we see that new strategies are coming, new structures are put in place, new standards are followed. Attribution is a major issue when it comes to cyber diplomacy, and cooperation with peers cross-border is also a great area of additional efforts that states invest into. But we also see there's a whole lot more of international efforts. Well, think of the UN, the GGE, the OEWG, the POA, which was discussed yesterday at the winter school. And we also see that cyber capacity building is also an area where nation states and organizations, they invest heavily into. So for instance, just to mention 2 perhaps players, if we will, both the US on one side of the Atlantic and the EU on the other one, have highlighted cyber capacity building as a collective priority that needs to be addressed. So the big trends are really shared worldwide. So investing more into national capacity and resilience, as well as investing into the same thing but cross-border and where it needs to be done. Because in the overall picture, of course, cyberspace is a shared good, and it makes sense to have a very cross-border approach rather than a very nationalistic one. So let's discuss very quickly a regional approach. So obviously between the global approach and the national one, there is also the regional approach. And just to highlight some of the steps that the EU has been pursuing, well, broadly speaking, 2013 was the key year for the EU to start arranging things in cybersecurity in a European-wide approach. So the first cybersecurity strategy was approved. It was followed by the NIS directive in 2016, which already took the broad objectives into more practical ways and even means on a national level. In 2017, there was the cyber package. Essentially, it was the second cybersecurity strategy of the Union. 2019, the Cybersecurity Act, and 2020, Cybersecurity Strategy for the Digital Decade. Published on December 16 last year. It is thus a very new document to learn. But of course, that's not the end of the pipeline. You may have heard of the NIS2 directive, which should be coming. So a lot of is going on in the EU when it comes to cybersecurity and building cyber resilience in the European Union. Now, if we compare the regional approach to a national approach, let's take Estonia for an example here. So the path for Estonia in cybersecurity started somewhat earlier. Yesterday it was discussed that 2007 has been a wake-up call. 2008 was the time for the first cybersecurity strategy. 5 years later, the second one followed. You see that pace is accelerating, so already 5 years later, the third one followed. And now Estonia is working on its fourth cybersecurity strategy. But TVA here, I will stop here. We'll discuss the results when they're out there to be discussed. But overall, you see the Estonian approach was a very pragmatic one. So first, you need to establish the strategic framework. You need to establish the proper institutions, so who does what. Then you need to enhance the capabilities, so who does what and how. You also need to consider crisis management issues because, well, a cyber crisis could be a national crisis. So that was very heavily in the discussion some 7-8 years ago. Prevention, international cooperation, very heavily featured in the third strategy, so on and so forth. Having first the means in place on a national level and then expanding to the international level, that has been either on purpose or this is how it turned out. That has been the evolution of the Estonian approach. Let's discuss very quickly what a sample organization could be. So I won't look for any faraway examples. Let's take RIA, the Estonian Information System Authority, which is in many aspects the cyber agency of Estonia. And RIA essentially has two broad areas to cover. On one hand, it provides the basic infrastructure and services of the e-state. So in Estonia, many normal government services have since long been run online. The electronic identity, trust services, state portal, data exchange services, state network services, and also e-elections. They are part of the Estonian e-way of life, and RIA is in charge of safeguarding all of that. And on the other hand, of course, you can digitalize many things, but you need to also take into account what's the cybersecurity behind that. So you cannot have a digital society without cybersecurity, and cybersecurity incident management, information security measures and surveillance, critical information, infrastructure protection, analysis and policymaking. These are then the key pillars under the cybersecurity pillar at RIA. So essentially, you see here again a comprehensive approach to how to enhance resilience and achieve resilience in cybersecurity. And then here are perhaps the key takeaways from this very short briefing. First of all, the lessons learned. It's all good to develop approach and the plan for a concrete area, but you need to understand that everything is cross-dependent. From digital infrastructure to energy to transport to banking and finance. In no society today you can assume that one sector is, or one or many sectors are not dependent on digitalization and cybersecurity behind that, and that you can ignore those considerations. No, you cannot. So you need to understand that everything is dependent and everything matters if you want to keep your society running. Secondly, you need to recognize the capacity gaps. So, well, there is no one-size-fits-all solution in cybersecurity. All countries are different, and you really need to identify all the different sectors. So from the very individualistic, so citizens level, all the way to the strategic leadership of the country, the government, parliament, president, or the vital services providers. Anything could end up as a target. And on the other severity scale, as you can see, well, the severity of an incoming cyber attack can be very different. It could be, somebody trying to establish what you have. What are your capacities? What are your capabilities? What sort of systems to use? So basically spying on you, all the way to someone trying to cause extended service disruption. So you really could benefit from a considered mapping exercise of what you have, what are your vulnerabilities, and how you approach each one of those categories in the most efficient way, so that in the most extreme case your society won't fall. Lesson learned number 3: you need to prevent. So on the screen you see the Estonian way to approach this challenge. Rather than dealing with the consequences, it's best that you educate your people, you educate them how to behave reasonably, how to behave in a secure manner online. Ole IT-vaatlik essentially means be IT prudent, be prudent in cyberspace. These have been now 2 iterations of a similar campaign that has been launched nationwide. It suggests, I would say, responsible ways of behavior online, renewing your passwords, not downloading unknown attachments, not clicking on links. So really practical advice to all the different sectors in the society. So better prevent rather than deal with the consequences. Lesson learned number 3, cyber hygiene. So in addition to preventing, you also need to educate people to making those secure or proper ways of online behavior a matter of normality. So here you see a radar screen that's a test taker in the Estonian government institutions, where it has been made more or less mandatory for everybody. Once a year, government officials in Estonia undertake a cyber awareness test, cyber hygiene test, where they basically are facing situations from everyday life, and then they provide their answers, and then they get a picture, a self-assessment as to whether the choice made is really cyber secure, or he or she should pay special attention to 1 or 2 areas where the behavior might become a vulnerability and a risk to him or herself or the organization. And just not to advertise any commercial providers, but just as a role model, during the pandemic, Estonia also made a similar test available online, so anyone around the world can have his or her approaches assessed. And then the last lesson learned really here is that you need to recognize the need for an international approach. So if you want to have cyber resilience on a national level, here are some, how to say, very practical and down-to-earth recognitions that really the cyber threats, the cyber insecurity is not going away anywhere. Rather, the sophistication scale and tailoring of attacks will only grow. You need to maintain situational awareness. You need to work with your ability to attribute. Attacks over IPv6 network, I recall IPv4 over IPv6 was a major issue back like 5 years ago, but it's very much still there. Keeping up the networks and services under intense pressure. Well, we've learned of several campaigns where attacks targeting one sector really go global in a matter of a short period of time. Security of ICS and SCADA, cyber hygiene, practical collaboration and information sharing. These are all very practical and down-to-earth things to be aware of when you want to develop your society in a cyber resilient way. And last but not least, well, cyber is and will always be a cross-border issue. So having a very national approach doesn't always suffice. And that has been evidenced by state practice, where a search for collaboration partners and cross-border cooperation is very much pursued. And that was the slides I had. I hope it was useful, but I would take the opportunity now to let Tõnu speak, and then we can entertain any questions later on. So thank you very much for your attention, and see you soon.
Thank you, Siim. And Tõnu, please, the floor is now yours, and then we'll take Q&A in the end.
So, thank you, Heli, for allowing me to, or inviting me to speak in front of such a distinguished number of guests. Good morning, good afternoon, or good evening, depending on which time zone you are. I understand there are a lot of people across different time zones. As Siim and all the four speakers already covered, I will try to give the little cherry, the technical cherry on the cake, and explain a little bit how you actually should perceive, at least in my view, in building the technical resilience, not only focusing on one side of the country, i.e. the government, but you should really focus on the whole country. And these are just some of my thoughts that come to mind when thinking about these matters. So first of all, a term CERT has already been mentioned a couple of times. The alternative is CCERT. I've given you an explanation of what a CERT or Computer Emergency Response Team is, or what a CCERT is, Computer Security Incident Response Team. Two terms for more or less the same thing. We need to recognize that the term CERT is actually a registered trademark owned by Carnegie Mellon University, and for us, we are authorized to use that, so we are able to call ourselves CERT. When we talk about our duties, this is to manage primarily cyber incidents pertaining Estonian cyberspace, and to monitor risks, threats, and interact with our government partners, our critical infrastructure partners, or partners from the general public. We operate 24/7, and our key focus is to facilitate the exchange of information, to gather information, and to push this out. So we are trying our best to keep our little corner of cyberspace as aware of the different risks that appear not only in our corner, but actually across the globe. And through these bits of information that we are able to elevate to the awareness of different actors, we are helping to build a better cybersecurity. With regards to some of our key tasks, well, of course, monitoring and early warning is the key here. We are keeping an eye on Estonian cyberspace with regards to different phishing campaigns, malware campaigns, a variety of different malicious activities. Often when I hear people talking about different capacities, etc., mostly in the context of capacity building, the techie sort of wakes up in me. And I wonder, are they talking about capacity building or capabilities building? Because mostly the projects focus on capabilities building, so that you're able to, for example, analyze malware. The question is, are you able to do this one sample a day, or are you able to do this 10,000 samples a day? For us, the key in protecting the country is move beyond capabilities building to a proper capacity building, so that we are not only able to execute the task once, but do it repeatedly hundreds, thousands, or even tens of thousands of times a day. As regards to monitoring the cyberspace, we are not only focusing on threats within Estonia, but we are trying to extrapolate things that we see across the globe with the view of predicting what could come to us, because only this way we are able to predict and be ready for the wave that could hit us. And of course, the real value is made only when the information is put into use. There is, how I put it very bluntly, there is no point of lingering on top of the information. It's key to put that information where someone can actually use it. So to turn this into an actionable information and to do this in real time. And we are able to do this through the clever use of IT technology. The other part on not only being silently observing what different criminal activity or adversaries are doing, is to try and make ourselves more technically resilient, to deny the opportunity for the criminal actors or state actors to do their deeds which most of us don't consider so nice. So we are talking about a proper deterrence, and here we have taken a very proactive approach in the sense that we are trying to keep an eye on the variety of public services which are available for our citizens, our residents, but also people across our borders. And we are constantly keeping an eye on how the systems and services perform, and whether we are proactively able to identify weaknesses that people with not so bona fide intention could potentially abuse. So we're trying to build technical resilience also through proactive monitoring. And advise our constituents to constantly keep up with the so-called best practice with regards to cyberspace, or to use the proper standards. One of the standards that I have particularly mentioned is the ETSI standard with regards to IoT, that simply requires the manufacturers to follow certain principles that make the life of an end user or consumer a lot better than if you would allow the consumer to do all this, but it requires technical skills that most people are not so prone to. So the security is already built in, and this is something that we are keen in looking. Now, the key element on this is not only that you do the talking about cybersecurity, but that we actually do it. I have used one of the testing tools that we use to compare top 500 sites globally, and then use some of the top sites in Estonia. And when we do the comparison, you know, Estonia is relatively a small nation compared to some of the big corporations that act on a global scale. And when I look at these numbers and I see that we do better on most key services that people every day use, it makes me proud, and it makes me feel like that we've achieved something. Because when we started this project, trust me, the numbers for Estonia were not so good. So it shows that we have made indeed a progress. Another important aspect is to work with our partners across the globe, because internet is also global. We are proud members of FIRST, which is the biggest global community of certs and C-certs, and we are members of TFC cert for more than 10 years now. This year we actually celebrated our 15th birthday or anniversary. In terms of cyberspace, 15 is already senior, so we have been around for longer than even the strategy has been around for Estonia. And with the help of CCERT and under their standard, we are among 9 government and national CSIRT teams who have achieved the highest ranking in terms of capability and capacity and matureness. And one other aspect that sometimes is not looked upon. Where do we all stand on a global scale? The best comparison with CERT or CSIRT teams are Red Cross or Doctors Without Borders. We, according to the UN norms, are the team that is not able to conduct anything that is considered malicious. This is also stipulated quite clearly in our primary legislation. And according to UN norms, nor should anyone attack us or cause any destruction towards us, because we are not there as an adversary to anyone. We are there to try and keep everyone alive in the world that we are, also in the internet. So I will say thank you with regards to the presentation, and if you have any questions, I believe, Heli, now is the time.
Thank you, Tõnu. So if Siim, you could also join Tõnu at other part of the room where we are in the studio. So we have, yes, several questions received. And before we go to the questions from the floor, so I would like to ask you, Siim, about EU Cybernet, which is in your job title. So you are the project lead for the EU Cybernet. Can you tell us what is the Cybernet and what are you doing as the head of Cybernet?
Well, EU Cybernet, as the name suggests, is a EU-funded project with a global mandate to help EU to build capacity, cybersecurity capacity. It was launched in 2019. It's implemented by RIA, the Estonian Information System Authority, and with advice and support from our advisory board members from Luxembourg and Germany. And as I mentioned, the mandate is global. EU is is the biggest actually provider of development cooperation, and cybersecurity and digitalization are increasingly part of that package of the EU's efforts. And as mentioned in my presentation, well, you cannot really digitalize anything without considering the cybersecurity aspects, and therefore the EU and the European Commission realized that it is timely and necessary to better coordinate all the good work that is being done by EU in terms of the various projects, such as, for instance, Cyber for Development or EU Cyber Direct or Glassy Plus, and so on and so forth. So a lot of good work is being done. Our role is to help secure that the EU speaks in one voice, so that there is coordinated efforts, and also that the EU's expert community is brought into the effort. So we try to establish a network of experts and institutional stakeholders of the EU Cybernet.
Thank you, Siim. And then we have a question also that has arrived about the combating cybercrime. And I guess, Tõnu, you are more prepared to take that question. It is about the penal code and the comparison of the Estonian penal code to some other countries like the US, where the damaging of data and imprisonment codes are different. I believe that actually Estonia, as a part of the European Union, is following the European Union harmonized cybercrime penal code here, actually. For the viewers outside of the European Union, it's just the explanation that all the penal codes in the European Union, I guess, are the same, and they are harmonized. But Tõnu, can you maybe comment on this, that there are still gaps internationally in penal codes and punishments for cybercrimes, and what shall we do about those gaps?
It's an excellent question. the fourth speaker mentioned about Budapest Convention. And I know I made more or less a year ago a similar presentation myself, that we still have a lot of countries who are players in the cyberspace. They do own a portion of the internet, they allow the data to move in and out, and by not enforcing certain regulations that should aim not to punish people, but to actually thwart them from conducting criminal activity first and foremost, this can lead to the criminal activity actually being used. So in my view, it's important that the countries who have not yet signed up for the Budapest Convention do that. We recognize that today's version might not be quite perfect, but it's a lot better than if we go and leave that area untouched completely.
Thank you, Tõnu. And a final question to both of you. So if some viewers outside European Union or more technologically advanced countries are watching now and asking the question themselves, how exactly this national resilience building should come together in terms of organization and technology, and what is most important, is putting the CERT in place, the first task, or having a strategy and vision and policy in place, the first task. So how would you assess what is more important? I know it's not like a kind of yes and no question, but maybe you can elaborate a bit how you would see the order of capacity building in terms of technical part of resilience and organizational part of resilience.
As I am already warm, I can answer the question first. In Estonia, the order was in the way that first we had the CERT established, so the focus was on technical level. Then came strategy, and after that came legislation. So we had a very bottoms-up approach. There are countries who try to do the other way around. In principle, as long as the different elements come together, the order does not necessarily matter much. Each country is different, so it would be incorrect to say that one approach fits all, but those three areas together are absolutely important.
Well, if I can complement, I mean, you really need to have a comprehensive approach, and you need to make sure that eventually all your corners are covered. So you cannot leave any area really untouched or unguarded. So my recommendation, speaking as a former academic, well, in order to cover all the corners, you need to see what you have, and you need to understand what you need. So once you have done that, then you start building your national capacity incrementally, so step by step. And what's good about today's situation is that there is actually a lot of capacity building assistance available from the EU. So I mentioned the different projects. So for instance, if you are in a country where you could benefit from more capacity building assistance from the EU, I mean, just let us know. Send us an email, contact the local EU delegation. You can reach out to the European Commission, and then we can take it from there, see what expertise EU has available, put together a mission and take it from there. So, I mean, the EU is the world's biggest development cooperation provider. Cybersecurity is part and parcel of that, increasingly important. And we do our best to bring together the best experts who are willing to share their knowledge. I mean, it's in everybody's interest that cyberspace is as evenly safeguarded and that we speak the same language worldwide.
Thank you, Siim. So I'm sure that your mailbox will be a bit busy next few weeks now after this announcement. So I hope that, yes, everyone who has heard your call to approach you will approach you. So thank you. And with this last cyber resilience panel, we are now ending this session, this training session, which for us is a third globally available cyber training session. And we have heard quite good overview of what is on plate when we discuss the global cyber issues. We started with the norms of responsible state behavior, the developments in the United Nations First Committee, the questions of how international law is applying, what type of regional organizations and confidence building measures have been put in place at the regional level. And we also discussed quite in-depth the issues of capacity building, the challenges of capacity building, the coordination of capacity building, and all those issues which we are now discussing in the United Nations First Committee working groups and also elsewhere at the regional level. So I hope this was useful for you. Please send us feedback, and you have our contacts on the website. And we hope to also follow up with similar events, maybe a bit more tailored, different. We will ask the feedback from different regions. And of course, I would like to thank now, in the end of this training session, many of our partners here, the technical team from the Estonian company Global Virtual Solutions, who have been running with the cameras around and making sure that the lights are on the speakers put properly and so on. And of course, I would like to also very much thank my team, Karin and Britta, who have been instrumental in helping. So we basically did it with 3 people, yes, that's right, as MFA team. And of course, I'd like to thank all the brilliant speakers who have found these hours in their very busy schedules to join our winter school. And so hopefully we will continue with our training efforts here, possibly during the summer, because I just checked now it's -12 Celsius outside in Estonia. So I think this experience is a bit harsh, even, you know, for seasoned cyber people. So I would wish you that you stay healthy, and I hope to see you in Tallinn in summer during the next years. Thank you.